morning. We formally get ourselves started. I think all the IT equipment is all ready. Good morning and welcome to oral examination into the Berwick Bank Wind Farm Onshore Works Compulsory Purchase Order 2023. My name is Paul Coquette. I'm a reporter appointed by Scottish Ministers to report on the justification for and objections into order and to report accordingly. As a role as a reporter, my remit is to note and make findings and recommendations in relation to the issues arising, and ministers will make a decision in relation to the confirmation of the order. Ministers have options in relation to confirming the order, refusing to confirm the order, or confirming with modifications. As we'll hear, there's other processes dealing with different aspects of matters under consideration, including also under the Electricity Act, Section 36, into the offshore turbines, and we'll no doubt touch on aspects relating to planning permissions and some of the interactions between all of those. This is day one of what may be 9 or possibly more days of sessions. The procedures will apply are slightly different according to different objections, but for today's procedure, it's a hearing session, and that means that it's not a process where there's formal examination and cross-examination. It's a discussion that's led by me, but with parties contributing to it in respect of their different interests. Technically, all the questions are asked through me, but I'm reasonably relaxed about the way in which we participate this morning, so long as the parties and anybody present is respectful and ask relevant questions. Then hopefully we can have a useful discussion to explore the issues that have been intimated and advised in advance. These sessions starting today were advertised in the East Lothian Courier on the 14th of March 2024. They are open to the public. There's one person who's identified themselves as a member of the public, so who's very, very welcome. This is a public hearing and a public inquiry. Members of the public are entitled to be present at these sessions, although the participation in them are restricted to the parties that have intimated and advised of the issues that are relevant for consideration today. As you'll have noted, these sessions are being recorded and are being live webcast, and participation in these sessions is treated as giving consent for the purposes of the recording of images and contributions in relation to data protection and GDPR. I think hopefully all of you will have had access to the Wi-Fi code that was left, so we can access all materials. I know we've all been given materials, so we can hopefully access the quite significant number of documents that are available. One advantage for everybody, but including me, is that the webcasting of these proceedings means that compared to the olden days, we don't have to worry too much about taking huge amounts of notes. I'll be taking some notes as we go, but we'll all have access to the webcasting at a later date. See, it's live available just now, but can be searched under the DPA website by searching under the case reference number for DPA, which is CPO-210-2. As I say, there are a lot of documents. Most of them are now uploaded on the DPA case management system, but hopefully are available today and for all these proceedings. Those that are not uploaded on the CMS quite yet, I know there's work going on to finalise the uploading of those that are outstanding that should be completed in the course of today. All documents relevant to the hearing are accessible in the same way. Of those may well have redactions in circumstances where they are may contain material that is relevant only to the parties but not to the wider members of the public. Obviously people today will see certain of the materials, but there are some documents in the course of the days that will be sitting that contain commercially confidential material, and if any members of the public wish to access that and there's some difficulty doing so, then you can discuss that with me and we can work ways around ensuring that those who are participating in this process, parties and myself and members of the public, can have proper access to any materials without breaching any commercial or other confidential matters. So if anybody has any concerns about documents they wish to access and can't, that may be in that category, then speak to me at any time and we can take that forward. As I say, there are tablets are the materials by which we could access most of the documents. There are a couple of plans that I think are likely to be referenced, and I personally find that slightly easier seeing hard copies of those plans. The two that I've identified so far for the purpose of today, one of which is I have some questions of the acquiring authority. I know Mr Ainsley is not represented here today, but I have a couple of questions that I'd like them to explain a bit more about Plot 27A, and I'll be provided with a copy of the plan so that I can access and see that. But I'll be asking some questions, and it may be that accessing a hard copy of that, which I've been given a copy of, might be quite useful. And in relation to Mr Jimison, I was given at the last site visit in December a copy of Viewpoint 6 at Branxton, and because I'm keen to properly understand the Branxton substation and the wider implications, including for Scottish Power, but also for Mr Jimison, I know Scottish Power are not going to be here. I'm intending to ask questions under reference to a laminate of Viewpoint 6 at Branxton that I was given and held on to at the last site visit. So most documents are accessible through the materials available. I gather that the internet connection in this hall can be unpredictable. I think was the word that was described to me, which is probably a very tactful way of describing it. So if anybody is having any access difficulties with papers, please say. And related to that, again, from my perspective as well as perhaps others, including parties unrepresented, it will be useful to be patient while I and other find documents, if you're referring me to documents, while I search for them to get to the right papers. And if anybody's referring to large documents, in addition to identifying the document, it would be useful to identify the page or paragraph number that you want to refer to, and take a little bit of time so that people can keep up with finding the documents that are there. We've had some recently produced documents on behalf of the acquiring authority, such as overlays with planned works and various things. That looked useful from my perspective. I haven't had any intimation of any objection to those being lodged, although they were lodged late. And on that basis, unless anybody objects, I'm content to accept them for the purpose of this examination. I'll come in a minute to ask the acquiring authority something about modifications, but generally for documents, it has been useful to have these before me. As we all know and probably sense, as we're sitting in a room with many people wearing suits, this is a formal procedure, but I do appreciate that for certain people it's one they'll be unfamiliar with. They very probably haven't been involved in anything similar to this before, or know the etiquette. However, as far as possible, notwithstanding the formality, I hope that matters can be progressed in as relaxed and informal a way as possible, and that the proceedings can be as accessible as possible. And I would emphasise that if any party at any time doesn't understand what's going on, or is uncomfortable with anything that's said, or feels they're being treated unfairly in the way they're making points, or are not being allowed to contribute in a way they would like, or otherwise being treated in a way in which lacks respect, please let me know. Just say if you feel uncomfortable at anything, and in doing so feel free just to interrupt. Don't worry about that, which is absolutely fine. And equally, if anybody needs a break at any time for whatever reason, please just say at any point in the proceedings. I've not been advised of any person with any special needs or requirements that require to be accommodated to support participation in these proceedings, such as hearing or access difficulty. It looks so that access is possible to the hall here, but obviously please advise me if anything issue arises there. As I say, strictly all questions are posed through me in hearing sessions, but I'm pretty relaxed about the way we deal with things, as long as it's done properly and to maximise efficiency in the proceedings. Although I would emphasise again the importance of being respectful to other witnesses and try not to interrupt until they kind of reach the end of their answer. Sitting times for these hearings for the days we have them would normally look to start at 10 o'clock. We'll play this by ear as we go, and sitting till 4 o'clock would be the norm or the default, with a lunch break between 1 and 2. I'm intending to have sort of micro breaks. I'll say a little bit about the shorthand writer, who's got the toughest job of all, as ever, in these proceedings. For the benefit of the shorthand writer, we'll take a micro break this morning at about 11:30. We may, of course, reschedule and depart from the originally planned timetable that we're looking to be adopting if matters progress slightly different from that which is anticipated. And I should say, as advance notice of that, we have the 2nd of May that's kept as a reserve date. I can no longer make the morning of the 2nd of May. I hope we wouldn't need the reserve date anyway. I can make it here for the afternoon, but for personal reasons I now can't make the morning of the 2nd of May. During breaks and overnight, it's probably safe enough to leave equipment here. I gather those instructed by the Inquiring Authority have arranged for the coffee this morning, and maybe even providing some lunch for everybody who's in attendance, which is very kind. So it may well be that there's no need to leave this room over lunchtime. This hall is not being used this evening, so it's possible for certain equipment or papers to be left overnight tonight, though again I would urge safety and caution about anything that's anything of very personal value, such as laptops. So there will be some capacity to leave papers perhaps overnight, but that only applies for tonight. The hall is used in the evenings on all other occasions, so we'll have to be out each day of the hearing on future occasions. So I'll say a little bit more in a moment about the procedure we're applying, but I'll maybe stop just now just to welcome everybody and ask if parties could introduce themselves and their witnesses, and starting on my left. Generally on the left and the far end of the table are the Acquiring Authority, and on my right are the objectors. But Mr Mackay, I think, for the Acquiring Authority.
Yes, good morning, sir. Thank you. My name is Marcus Mackay. I'm an advocate and a King's Counsel at the Scottish Bar, and I'm appearing along with my Leonard Junior, Mr Nick McAndrew, who's sitting two to my left. Together we're instructed by Gillespie McAndrew solicitors, in particular by Ashley McCann, who's sitting to my right, and also by SSA Renewables Legal Department. So we have a few witnesses.
Yes.
It's us being button flashing out.
Also, we'll be always what we've done.
Pete. No, just not.
This is the Wi-Fi.
No, it doesn't.
Yeah. Hopefully you can hear me now. Great. So yes, we have a number of witnesses present this morning. And I actually thought it might be worthwhile them just introducing themselves, because there are so many. You have a note of their names and designations. Great. Well, if I can ask Mr. Bell to start, and we can just go around the table, please.
Good morning, sir. My name is David Bell. I'm a chartered town planner. I'm acting on behalf of the Acquiring Authority in terms of planning policy and other planning-related matters relating to the applicable circular. Thank you.
Hi, I'm Jenny Dyack. I'm a principal ecologist, ITP Energised, and here to speak on ecology matters.
Hello, I'm Victoria Porter. I'm a chartered surveyor and the lead land manager for SSE Renewables on Berwick Bank.
Good morning, sir. John Hillis
from Black Holland Powys, witness for the acquiring authority on matters connected with land assembly.
Good morning, sir. I'm Sandra Langdon. I'm a Senior Project Manager for SSE Renewables, and I will be a witness for matters relating to the off-toll regime.
Morning, sir. It's Paul Danborough from SSE Renewables, and I'm the witness in regards to routing and site selection.
Morning, sir. I'm Sarah Edwards. I'm the Interim Development Manager for the Berwick project, and will be the witness in relation to consenting and other matters.
Morning, sir. I'm Conor Manning, the Berwick Bank Engineer Manager, and I'm here to serve the inquiry on engineering matters.
Hello, my name is Sunita McKillop, and I'm the Civil Engineer for the project and acting on behalf of the acquiring authority.
Yes.
Morning, sir. Yeah, Ben Gloag, Electrical Engineer Manager with SSE Renewables. Thank you.
Good morning, sir. My name is Colin Hamilton. I'm a partner with Gillespie McAndrew, Solicitors to the Acquiring Authority, and seated behind me is Amy McDougall.
Morning, sir. Ashley McCann, Solicitor with Gillespie McAndrew and to the Acquiring Authority. Thank you.
Later in the inquiry session who may have had some concerns of availability because of lambing commitments. Was it Mr Blanche, I think, was one, and I'll ask the same question for Mr Dunlop as well. It would be useful just ahead of further sessions which are due to start on Wednesday, if you can have a given indication, at least as of now, whether there are any concerns regarding witness availability in those regards.
No, sir. I think the witnesses are all available for those sessions.
Good morning, sir. Mr O'Carroll, for the firm of Dunlop and partners thereof. I have to indicate that, as currently instructed, Mr Dunlop Senior, who had anticipated leading first, will not be able to attend the session. I've had to think about what to do in those circumstances, but I think the best I can do would be to ask this inquiry to treat his precognition as being a written statement. Obviously, it won't be available for cross-examination.
Well, we can address that on Wednesday morning, but that's very useful to know that was one of the concerns I was wanting to raise for his availability. I mean, I think it's his statement I've obviously read, and the kind of I was anticipating that the main issues for examination would be of the witnesses on behalf of the firm of Dunlop more than Mr Dunlop himself. But I don't know if Mr Mackay has any comments at this stage. We can address this Wednesday morning if needs be.
This is the first I've heard of this, sir, so I'll give it some thought and confirm. I hope so. Has everyone had a chance to say hello?
Yes, so formally then, I'm Maurice O'Carroll, member of the Scottish Bar. I'm instructed by Messrs Turk and Connell to act on behalf of the firm of William Dunlop and the partners thereof. I'm instructed by Louise Johnson, a partner with Turk and Connell, and also Mr Chris Hoyle, who is here to my right.
That's great, thank you. And going up the table, we have Mr Jameson.
Good morning, sir, and everyone. My name is Kevin Jameson. I am a resident near the proposed Branxton substation, and I am a non-statutory objector in this process. Good morning.
Okay, thank you. And then Mr Armstrong.
Good morning, sir. My name is Douglas Armstrong. I'm a member of the Faculty of Advocates and King's Counsel, and I'm appearing on behalf of NNG, instructed by Shepherd and Weatherburn, and George Bruce from Shepherd and Weatherburn is to my right.
Okay, thank you. I've had intimation that George Alexander Ainsley, Brian Byrne Ainsley, and the firm of G and BB Ainsley are not going to be attending this morning's session. I've also been advised that Scottish Power Transmission and Scottish Power Distribution, represented by Shepherd and Wedderburn, are also not going to be attending. They were originally potentially down to be attending for the afternoon session starting at 2 p.m. today. I've also seen an email from them from Friday which gives an indication that negotiations and discussions are ongoing with the acquiring authority, and they hope to be able to update their position in maintaining their objection, but they hope to be able to update their position by the close of the inquiry. So there may still be questions that we address in relation to that not coming to pass, but they certainly don't intend to be appearing or represented today. And we're also told that Tarmac Cement and Lime Limited, represented by Alana Barker of CMS CMNO, are not going to be attending the session today. And although Mr Hoyle is here, we understand from an email again I've seen this morning that the firm of Buffetts are not intending to be represented or contribute to the common issues sessions that we'll be addressing this morning. That's my understanding of the position in that regard. So thank you for that. Today we have a hearing session covering a range of cross-cutting issues, as we have advised to parties before. We have tomorrow allocated, we have this morning allocated for common matters, and then at 2 o'clock this afternoon a session assigned to deal with Mr Jimison's objections. And as I say, there will be no appearance by Scottish Power. So the running order had planned for that, continuing the common sessions tomorrow, and then moving on Wednesday, Thursday, and if needs be Friday morning, to an inquiry session in relation to Messrs Wound and Lop, with Friday afternoon being held in reserve. Next Monday and Tuesday, we have hearing sessions set aside for Tarmac Cement and Lime Limited, and on Wednesday, 1st of May, we have a morning session set aside for NNG, and an afternoon session set aside for the firm of William Muffet. I know there's a bit of discussion still in relation to what we do about the Muffet objection, because there's been some toing and froing as to when other evidence might be heard. I don't know if Mr Mackay, you want to address anything for the more immediacy of it might have an impact for tomorrow or later today in relation to Muffet.
Yes, certainly by the end of today, sir, it would be very helpful to have an indication as to whether the Moffat-related, specific-related hearing session is proceeding at all. The reason for that is that I don't know whether you have picked this up this morning, but the agents for Mrs Moffat's Turk and Connell have indicated they do not intend to participate in the hearings if they do proceed, although they are presently maintaining their objection. So it may be a matter to give some further thought to, sir. If the requirement in any matters, then we're happy to attend. But otherwise, we are assuming the hearing sessions from office will not be proceeding. But as I say, it's a matter would be useful to have confirmed.
Okay, thank you. Mr Howell, do you have any further to say about that, or any further information in that respect?
The firm of William Moffat, although they're not intending to appearing in the hearing session, they are maintaining their objection at the moment.
Just so I'm clear about that, I picked up they weren't intending to appear today for a common hearing session, and by taking it from that, they don't intend to appear for any of the sessions.
That's correct.
So that's fine, so that's useful. So that we can at least plan at this stage on the basis that the afternoon session of the 1st of May will therefore not be needed, and that we don't have to look in terms of the juggling we were doing in terms of witness availability for other witnesses. So that's helpful from that perspective. So thank you for that. As I mentioned already, as I gathered, on my immediate right, we have a shorthand writer present. This examination is being webcast, but the acquiring authority have indicated a wish to have shorthand writers present, which I'm content with. In the hopefully unlikely event that were any difference between the version of events that arise, as noted by the shorthand writer, and the recording through the webcasting would normally prevail, and we're trying to make arrangements so that the shorthand writer's equipment doesn't interfere with the webcasting, but there's been no suggestion that may be a problem. I gather that the shorthand writer's version of the proceedings can be made available to parties if they wish to see them, available to all parties. If anybody wants to see the notes taken by the shorthand writers, they can apply to the acquiring authority and they can no doubt share them if anybody wants a copy of that. And as I say earlier, when people make their first contribution in discussion this morning, if they could say what their name is, then that can be noted by the shorthand writer. I'd like to just to ask in relation to a document concerning modifications. There are potential modifications, I think, were intimated in the course of last week, and parties here today may wish to comment on that. I think the note of the modifications, which comprise both modifications to the order proposed by the acquiring authority and modifications proposed by certain other parties which are acceptable to the acquiring authority, are contained in that document. That's how I read what was being submitted. They have been sent on to all parties. It is actually on the agenda for today, but we may or may not need to address that. I've got one question I want to ask about the process of dealing with the modifications, but that would, it seems, given that this has come relatively late, I think it's been intimated to all parties, but I was intending to give an opportunity to those here today and elsewhere to have a time period. I'm going to suggest till the 2nd of May, since that's the end of this process, to make any comments they have on the modifications as they think fit, once they've had a proper opportunity. If they know that the acquiring authority can make the modifications available if anyone wants to consult with them. But that's what I'm saying. Modifications only, whether I confirm and that's accepted, or whether I recommend refusal, Mr. Still. And I should emphasise that to engage through the formal process. Oh, sorry, I beg your pardon. We have an IT problem. Okay. Right. Is that any better? That sounds okay. And I was just going to emphasise that if anybody wishes to make any comments in relation to the modifications, I will entirely understand that as without prejudice to the fact that they are otherwise objecting, so that if they wish to say anything, that will not be taken as being a concession in relation to their outstanding objection. I don't think there's any objection. If I give till the 2nd of May that everybody must comment, I'm happy that nil returns don't feel they want to open to them. Then, but that I think might be useful just to allow for opportunity. I think.
In principle, yes, sir. I think I would suggest, though, that if possible, parties could give their feedback, if there is to be any feedback, a day or so before the end of the inquiry, because that would allow us to use any remaining time, particularly the reserved day of the 2nd in the afternoon, if necessary, to discuss any issues that might come out of that.
Okay. Does any other party have any comments on that suggestion, or my suggestion, or indeed the modification of it? No, that's very helpful. Well, I may then suggest maybe by close on Monday the 29th. That will give a couple of days. So I will ask my case officer to issue something today so that that's on the record with that information requested there. Okay. Thank you for that. I think I have said before, and there was a procedural note that I issued on the 1st of February dealing with closing submissions, and I just emphasise again, for the benefit of agents in particular, but also Mr Jimison, that at the end of the procedure of this examination, whenever we get to it, I'm not expecting closing submissions by any party to be given on the day. There's a schedule set out in my note of 1st of February, which gives around a week, I think, for the objectors to make any closing submissions as they think fit, and 7 days after that for the acquiring authority. So just to put on the record, that remains my view, to save the midnight oil of council thinking that they have to prepare closing submissions before we actually complete this part of the examination. So with that, I don't know if anybody has any other points or any questions arising before we move into the first part of the comment session this morning. Mr Mackay.
Yes, sir. Just one other issue, and to the statement that was made by the Cabinet Secretary for the Wellbeing Economy and Net Zero Energy to the Scottish Parliament on Thursday of last week, discussing the content of the report from the Climate Change Committee. And that is an issue which I anticipate may arise early-ish in the agenda this morning. Mr Bell has prepared a briefing note, a 3-page briefing note. The intention was that was to inform the acquiring authority's position, but it actually serves as a useful summary of the documents that he has summarised. Those being the CCC report, the related press release, the statement to the Scottish Parliament, and a letter from the Cabinet Secretary to the convener of the Net Zero Energy and Transport Committee. It amounts to that material, but I think, sir, there would benefit that being lodged as a document for the inquiry, because it might save quite a bit of need to lodge other additional documents. So if you were happy for that to happen, sir, I would suggest that was received this morning. We have copies to be circulated. We need to be given a core document reference number, but we haven't done that yet until we canvass that with you, sir.
I first of all turn to the objectors. Mr Jimison had indicated before this morning that he would wish to make a reference to that too. First of all, procedurally, what do objectors or those representing them think is the best way forward? It may be that those of my right wish to make representations anyway in relation to that. It's not entirely surprised that this is an issue that will have relevance to all parties. So there's a procedural question, given that if these documents are received, nobody on my right will have seen them yet, so we'll obviously want to have an opportunity to look at and consider those. So my question, I guess, is whether any of the objectors want to make any general statement about the Scottish Government announcement now, and how we deal with giving a fair opportunity to see these documents if received. It sounds as if it is pretty sensible to have a bit of an update given the kind of newness of this development, and build in some time to give a fair chance to the objectors to express their view and to consider the documents if they are lodged. But I'll start with Mr O'Carroll on that.
Well, obviously it's a development of obviously overarching importance to all the matters that are basically underlying this entire procedure and process. But having said that, it's not the intention of my clients to make any specific comment on that, perhaps in general terms, perhaps about my closing submissions, but it wouldn't be my intention to seek to make any particular general statement with regard to it. But I would welcome the production of the document suggested by Mr Mackay.
Thank you. Likewise, I found it very interesting, all these recent announcements by the government, and just how that changes the entire political or environmental landscape or aspirations of the government. Like the gentleman on my left, I would like an opportunity to digest what's been produced so that I can better understand what is being said. But I think it does raise very interesting questions about how the government are pursuing their ambitions along the net zero road. So, yeah, I'm hugely interested and would like to read that and perhaps come back with any further questions. Thank you.
Got no issue with the suggested way forward.
That's sensible and helpful. I'm conscious that however quickly you're able to lodge them within about 15 seconds of doing this, that nevertheless sitting here today and therefore not able to look at them until today's proceedings. I mean, it may well they want to come in a little bit more to late age or that I think about to anticipate. The ministers, and it's the ministers' own documents, their own policies. So there's a degree to which they overarching nature and will need to make wider views and make wider decisions in relation to all of the consents that are before them.
Yes, absolutely, sir. Well, you've indicated there would be a mini break in any event, sir. It's already 20 to 11 nearly. I did wonder whether the most practical way forward would be to circulate the documents just now. Over the short morning break, Mr Jameson in particular can have a look through the briefing note, which, as I say, is 3 pages. Yes, there's some more detailed documents behind it. But he may feel able to use the documents in any way he wishes during the hearing this morning or indeed this afternoon. But we also have a second day slot for the common sessions tomorrow morning. So it does seem that if there are any issues that still need to be ventilated in relation to these issues, then they can be visited tomorrow. But in principle, it might be possible actually just to lodge them now and parties take account of them in this morning's discussion.
That's fine, yeah. I saw my little light went green, which told me, green tells me go and everything's all right. I think green stop isn't. So that sounds sensible. And if we do use time tomorrow, I'm conscious Mr Jimson may plan to have been here. If he looks at the papers and he wishes to come again when we're sitting at a subsequent point, then assuming that works for him, then that's clearly a possibility from that perspective. So thank you for that. That's sensible. I've noted this some time ago, a set of sort of common themes. Now, quite a lot of the common themes are identified overlap to a degree, and there are other copies that are printed off of the common themes suggested. All of them, to a great extent, have been addressed either in a hearing statement or in a written statement on behalf of the acquiring authority. But I am conscious also we have, on behalf of Messrs Dunlop, if I'm correct at this, we have a hearing statement on prematurity of the 15th of March and a rebuttal statement of the 28th of March in relation to matters arising. So, as I say, some issues that are identified there will overlap with each other, and some, I think, probably don't require a significant amount of contribution or discussion today because a sufficient amount has been dealt with in writing. I'm particularly interested in the first two of the topics, which is the issues about prematurity, its various guises, but also I'd like to hear a little the justification for the CPO powers as opposed to way-leave powers, and the fact that in various respects it may well be, we know, I don't know with certainty, we know that the licence duration, if granted, is 5 years. I'm conscious we're talking in terms of glacial timescales in one sense. 35 years is a very long time, but it's not a forever licence that's granted. And I'd just like to spend a bit of time this morning with the acquiring authority and those objectors, just exploring the justification for the compulsory taking of rights, whether it be full acquisition of land rights or the more limited acquisition through access rights and cable rights, where it is known or is possible at least that things are not kind of going to be a kind of forever issue. So they're the main issues. Many of the other ones, I think, probably are either superseded or adequately dealt with in writing. Now, in terms of prematurity, I had basically seen prematurity as falling under 4 potential heads, one of which is the interaction with the other consents, and the law have issued particular issues that I'll maybe ask Mr. O'Carroll to speak about in the interrelationship with the consent south of the border, effectively, that's the function of different authorities. But there are also there are consent processes that are relevant where the decision maker, as with the CPO, is also Scottish ministers. That's one set of category of conditional matters. And the other are those where there are other bodies who have the functions in relation to outstanding matters. And I'm conscious that one of which is East Lothian Council as the local planning authority, the Gas and Electricity Markets Authority, and certain CPO licences. And indeed there are other consents on non-planning nature required from East Lothian Council. So I think that general head of prematurity comes under a number of issues, and I'd like to explore some of those. The second prematurity argument, again made by the laws, is effectively that the CPO could have been unnecessary had there been proper engagement. Mr. Jimison may want to say something about that as part of the discussion. The third possible area of prematurity, I guess, would be a suggestion that there has been no proper opportunity to engage because objectors have not been sufficiently informed to make a proper decision as to whether they should engage or not. In other words, a lack of information. And that's an argument that's put forward. The fourth question, I think, is not with any party, is any question as to whether the notification requirements under the Acquisition of Land Authorisation Procedure Scotland Act 1947 were fully complied with. There were some initial suggestions, because the notification period straddled Easter last year, that the 4-week period had not been complied with. But my understanding is that from in the course of the various parts of consideration, that there are no parties maintaining that line of objection. I think that's my understanding, but the acquiring authority may be able to update from that point of view. So I was seeing premature as being basically under those heads, and the acquiring authority have dealt with quite a number of those. Maybe with Dunlop and the question of the interrelationship with the various consents that are outside the border, which is an interest to address us on his views. In fact, the acquiring authority, I think back in 15th December-ish, middle of December, I thought was a very useful determining status of those various things. So I was going to start. It might be useful if there is an update to any of the information. This, I think, probably came after the planning permission in principle was granted, so I know that. But if the acquiring authority have any information about the current status of any of these other applications, then that would be useful just to note down so that I know where we are on that. In particular, the situation as to whether Scottish ministerial consideration of the Section 36 consent and where we are on that. But I'll start with it's the Cambois. I don't know how it's pronounced.
Yeah, I've always thought it was Cambois. But...
Yeah, we'll call it that. It is for these purposes. Yes, Mr. Carroll.
So thank you very much. I think that's a very helpful place to start. But I wondered if I could, just at this stage, just go slightly one stage prior to that. Now, the one thing with regard to the prematurity statement, reference has been made to the document you talked about earlier, and that's been picked up on by the acquiring authority. who made reference, in fact, to the to their own production on the an update, in fact, of that document you've just been referring to. Just bear with me a moment. Yeah, so the actual up-to-date position, as we're told, is now to be found at core document 008.001.001, which is the project overview. And that is at pages 24 to 28 of that document. And that's been pointed out by the acquiring authority as being the more up-to-date position. But funnily enough, the actual points raised in the prematurity hearing statement lodged on behalf of Dunlops, paragraph 2.2, in fact, cover the same points and the same subject headings with the same points being made, and in fact unaltered by that update. But I think, strictly speaking, the correct reference should be the one I've given, 080101. But before I get to that, and what I propose to do is just to, I think I'll be guided by you, because there's a great number, as one would expect, for a project of this magnitude. There are a great number of other consents that are part of the mix, which would be considered as part of that, and it might be worthwhile taking them one by one. So I would say in relation to one and then seek a response, but entirely that's a matter for you, rather than try and take them all in one. But before I get to that, I was interested to note this morning, while looking at the front pages of today's newspapers, that the front page of the Times has the headline, "Wind Farm Delay Adds to SNP's Climate Goals Woe." And what we have, in fact, is an article in the front page of the Times dealing specifically with a consent about this very wind farm that we're dealing with, the Berwick Bank development in the Outer Firth of Forth, 4.1 gigawatt scheme. And it's stated in that it did not get consent from Scottish ministers in time to secure a power price guarantee from the UK government. So it seemed to me that that might be a very useful point to pause after I've stopped talking in a moment, to ask for comment from the acquiring authority. Now, what I presume the Times is referring to is the Section 36 consent. I presume that's what they're talking about. And obviously that will then have knock-on effects with other consents. And obviously it does tie in with the timetable that's been discussed many times in the past, understandably, in relation to the pre-inquiry meetings that we had, the timetable that we had that was relayed, and the reason for the urgency on the part of the acquiring authority to have this matter then come before this inquiry now, at this stage, and to seek compulsory powers at this stage. Presumably, part of that would be in order to have had the connection and the agreements with other regulators in place elsewhere, as all part of that chain and link in delivering the project and the energy which it will eventually produce. So, with that all said by way of introduction, it does seem to me that we already have an immediate stumble, if I can put it that way, in relation to a particular consent, which has had a particular knock-on effect, which does have a bearing on the question of prematurity and whether or not we really should be in a position of considering compulsory acquisition for the objectors at this particular point. So I think that I raise it for that reason, and therefore I would stop at this stage and ask that the acquiring authority comment.
I'm happy to give the relevant witness an opportunity to comment on that. I do recall, and I know your reference there is a reference to Section 36 consent, but I know there were some concerns about the timings of this process from the acquiring authority. I heard recalled those as relating to the potential for incurring additional delay costs, penalty costs that arose if the project progressed too quickly. That may or may not be the same thing as a suggestion that the lower price guarantee would be utilised, and that's what you're suggesting. It is reported by the Times as having been lost. So just putting on record that I was also aware of some anxiety because of the length of the process might have consequences, but it may well be a witness for the acquiring authority can give a response to assist in that respect.
Yes, sir, thank you. And first of all, sir, just to confirm that the Appendix 7 to the project overview topic paper is the current state of play in terms of other consents and the current status. So if you're looking for an accurate snapshot, that's the place to go. In terms of the general theme developed by Mr. Carroll, sir, you will be aware from looking at the Acquiring Authority's hearing statement that the issues of barriers to the scheme proceeding is something which the Acquiring Authority have approached in light of the policy guidance provided in the circular, and that, in my submission, is the proper context for that discussion, and that is discussed in particular from pages 5, 6 and 7 onwards in the hearing statement for the Acquiring Authority. So that in my submission, is the proper context. And in terms of the specifics that Mr. Carroll has raised this morning, following reading of the Times, in relation to the question of delay and any potential implications for funding, if I can pass, please, to Sarah Edwards, who is the primary author of the topic paper on the project overview, and she will be able to comment and assist in that respect, sir.
Thank you, sir. Yes, I'll just provide a bit of context. So the headlines are in relation to the Section 36 consent for the Berwick Bank wind farm not yet being granted, and that was in relation to the deadline for the eligibility window for the CFD auction round 6, which closed on Friday. Contracts for difference, so that's in relation to the power purchase agreements. In terms of what that means, we were always ambitious that we would have the consent in time for the auction round, but the auction rounds are held annually, so it's not the only, I suppose, only chance to secure those contracts. Those contracts can be secured on an annual basis. It's also not the only route to market for the project. There are alternative options that can be explored by the project. So those timescales and those deadlines not being achieved does not mean that the project, it does not influence kind of how the project can be taken forward or will be taken forward. And it doesn't raise any question over the ability to secure the consent, which I think is key for this discussion.
Do you have any indication or understanding from the Scottish Government as to a likely timescale for them considering the Section 36 consent?
We do not. We are engaging with Scottish ministers on a very regular basis. We speak to them bi-weekly on different topics that we're discussing. The reasons why the consent has not yet been granted is due to the complexity of the application and the amount of information. In particular, this is the first offshore wind farm in Scotland to go through a derogation case, and so consequently that has added to the timescales for determination, just due to the nature of the process that Marine Directorate have to work through. So they have to go through a sequential process to satisfy that they are able to pass each of the 3 tests associated with the derogation process to get through that. And our understanding from engaging with them is that they are currently working through those 3 tests at the moment. And it is purely just a situation of time and complexity with the application and the amount of information that they have to go through and the procedural nature of the application. It does differ to the DCO process in England, where there are set timescales, but we are now 14 months in from following submission, and that's fairly consistent really for consents being determined. Section 36 consents in particular being determined. Those timescales we're not massively over those timescales at the moment, so we don't have any concern from that perspective.
And you mentioned that the situation as far as the consents in England are concerned, that there are perhaps more specified or precise timescales for that. Could I ask the same question, if you happen to know it, about progress on the application, timings of the application down south? That may tie into what Mr. DeCarp wishes to address later on. Do you happen to know the answer for the commonly English consents, for want of a better phrase?
Yes, so the consents in England, so the Camis connection consents, the marine licence and the onshore applications, they're still being determined at the moment. The marine licence application, we've recently submitted some additional environmental information and that has been requested through the statutory bodies to answer some additional questions that they have in relation to potential impacts, but we've provided that information is being provided. Again, that's just a timescale consideration. The onshore consent is currently being determined by Northumberland County Council.
I was going to ask this question later on, but you mentioned derogations, and either you or Mr. Mackay might want to give a response to this, is to borrow the guidance on compulsory purchase orders relating to planning permission and apply it to the marine consents, is that one of the parts of Circular 6/2011 is that ministers need to be satisfied that there's a reasonable prospect that planning permission is likely to be granted and can still confirm a compulsory purchase order in those circumstances. You mentioned that the need to obtain a Section 36 consent offshore, both north and south, requires derogations, which on the face of it would suggest that it makes it perhaps less likely that you can be reasonably satisfied about the prospect of that, because you need to satisfy a derogation. So it's not like planning permission, where if you can point to the fact you comply with local development plan, that gets you quite a lot of the way there. I wonder whether either you or Mr. Mackay would want to say something, since you mentioned the question of derogations, as to how confident the acquiring authority are on the basis that they, both north and south of the border, require derogations from policy requirements for the Section 36 consent.
Yeah, absolutely. As part of our application, we submitted a derogation case to support this part of the process, because we knew that the consent would need to go through a derogation under the habitats regulations. There are three tests. The first test is that there are no alternative solutions, and we, as the acquiring authority, are very confident that we have presented a strong case that there are no alternative solutions to developing the Berwick Bank wind farm. The second test is in relation to IROP, which is imperative reasons of overriding public interest, sorry. Couldn't remember what the I was. And again, we feel very strongly that we've presented a very strong case, and we've presented very strong evidence to support Marine Directorate in going through that step of the derogation. The third step is to identify compensation measures. And again, we presented a very robust application which set out a number of compensation measures that we would be implementing, and we feel that again, we have not had any indication that those measures are not going to be implemented. We will be able to implement those measures and that they will be effective. So we feel very confident that the case that we presented for the derogation will be sufficient. It's purely a timescale consideration in terms of why the consent has not yet been granted, because Marine Directorate are working through each of those steps and they have to do it sequentially.
Yes, sir. In relation to this issue of whether or not the derogation case presents a barrier to the scheme, the Acquiring Authority effectively relies on the position explained by Sarah Edwards, that there's every confidence in the strength of the derogation case that's been presented to ministers. And I should mention that the derogation issue only applies in relation to the Scottish aspects. There's no separate derogation case related to the English waters and English connection. So although this would be not at all proper or correct to turn this CPO inquiry into a full-blown examination of the derogation case itself, mindful of the fact that this issue had been raised by objectors, the relevant information had been included within the core documents. Unfortunately, that means lodging quite a lot of documentation. Helpfully, however, our planning witness, Mr. Bell, has been involved in not only this CPO process, but also the planning statement and the justification for the Berwick Bank case. And in that context is included in his topic paper a review of the relevant information that supports the derogation case. And if I could bring Mr. Bell in at this stage, he can perhaps summarise what he took from that exercise.
Thank you. Yes, in answering, sir, I'll refer to one or two paragraphs in my topic paper, and I'll just emphasise what I think are some of the key points for you on the matter. Firstly, at paragraph 3315, this is in my topic paper. Sorry, it's 3315 on page 21, and I refer there to the applicant's report to inform the appropriate assessment, and it refers to the process that has gone on in relation to the derogation case. As Mr. Mackay said, I was involved in the planning case for the offshore wind farm. Therefore, the text I've set down there refers to some of the aspects of that case, such as the compensation and so on, that will feed into that derogation case, and also steps such as enabling not just Berwick Bank, but potentially other projects to come forward. So that's just by way of background, that before the ministers there will be other benefits, if you like, from the project. But in terms of what Ms Edwards said, in terms of this being the first derogation case in Scotland, it's not the first for the UK. And in my topic paper, paragraph 3335, I refer to several cases where the Secretary of State, south of the border, has determined positive derogation cases for offshore wind farms relating to special protection areas. So there is a strong parallel with the Berwick Bank situation. And paragraph 3337, I refer to the Hornsey 3 wind farm determination letter by the Secretary of State, and pull out a quotation there, which references the essential benefit of that development deemed as being limiting the extent of climate change, and the Secretary of State says the consequences of not achieving that objective would be severely deleterious to societies across the globe, including the UK. And I go on to reference Hornsey 4 with a similar type statement from the Secretary of State confirming the clear imperative reasons of overriding public interest. And that is a theme that comes through in all of these decisions. And I also refer to a Scottish case, which is the paragraph 3343, which is the CPO decision report from the DPEA on the Western HVDC link. And in that, there is reference to the central policy, as it was then, of generating the equivalent of 100% of demand for electricity from renewable sources, and the public interest is referenced. Now, just pulling that to a close, what I do reference at paragraph 3344 is that in today's context of net zero, legal obligations and a more serious climate crisis and emergency, then the public interest in this regard with reference to energy policy is arguably even greater and holds much more of an imperative. So I would say, having been exposed to the technical case for the derogation for Berwick Bank Wind Farm, which I think is strong, as I've set down in the earlier paragraphs I've referred to, and having looked at the precedents that exist for other offshore wind farms when they have been dealing with impacts on SPAs, then that is giving the acquiring authority justifiable confidence that that is a potential barrier that has every prospect of being overcome. And the last thing I would say about that is that I've said that energy policy today is arguably even greater and holds much more of an imperative. The note that was put forward to the inquiry today perhaps even underlines that with greater certainty, namely the importance of acting now and quickly, and we'll perhaps come on to that, whether it's later today or tomorrow, when we look at some of the papers that have been lodged that would justify that position being taken. Thank you.
So, sir, just drawing this together then, to emphasise the point that's made at paragraph 14 of the Acquiring Authority's hearing statement, that when you look at paragraph 34 of the circular, that requires the authority to be satisfied that there's a reasonable prospect of securing any other permission, consent or licence that might pose a barrier to the scheme. And for the reasons expressed by Sir Edwards and David Bell, the acquiring authority is satisfied, sir. More than satisfied.
Mr. Mackay, I think you say, Mr. Bell said there are English cases where derogations have been looked at and consent has been granted despite that. I think you said that for this particular site, the one under consideration, the related application, does not require derogation. Did I pick you up correctly?
From an English consenting authority.
From the English consenting authority.
Yes, but Mr. Bell's drawing upon the general approach in relation to the various schemes identified at paragraph 335.
I'm taking Mr. Bell's evidence as being generally, but I think I'm going back to what you said earlier on, that there's no derogation for this particular site for the application south of the border. And the reason why I wanted to emphasise and make sure I properly understood that, Mr. O'Carroll, will have views on this, is potentially important. Because in any event, it's looking likely that my report will be before ministers around the time, possibly even before the time they make a decision. So there is at least an argument that they will have their own internal processes on the derogation around the time they consider the CPO report. So a question about whether the derogations, because it's the same deciding authority, it may well be that this issue maybe has perhaps less resonance than it might be had it been a different authority. Now, Mr. O'Carroll's point is, but the decision down south is a different authority, and we'll hear about that in a moment, but at least in relation to the Scottish Section 36, it's going to be the same deciding authority. I just want to be clear about that.
Yes, sir, I think Sir Edwards has an additional comment she wants to come back in.
Thank you.
Yeah, it was just to confirm on the Section 36 will be determined by Scottish ministers, but the reference to the applications that are in English waters and south of the border, the marine licence will only be determined by the MMO, so it's a completely different determining authority that's responsible for that part of the project, and the onshore application obviously is Northumberland County Council, so they are very separate consents in their own right, and the section 36, which is the key consent required for the wind farm, that can, that will progress regardless of what happens with the marine licence that is being determined by the MMO, and if, the two are not dependent upon each other, just to confirm that.
Okay, well, maybe, Mr. Carroll, you have questions about that. I think that's part of your other argument there. I think you'll be developing that, I think, as to the interrelation between the two. I'm wondering, do you want to come back on these points, or should I bring in, I don't know if Mr. Jimison has any questions from what he's heard from witnesses on the left, or whether you want to come back on this before I bring Mr. Jimison in. I'm easy either way.
I think if Mr. Jimison wanted to comment just now, I think that might be the best way forward.
Is there anything you want to say on what you've heard about the creation in response to that question?
Yes, thanks very much. I suppose I have to start off by saying I'm just entirely confused by all the interaction between what I've just heard about when the fact that the wind farm has not attained ministerial approval. I personally do not understand why that is not a huge big red flag to anything that subsequently is expected to follow. We then sort of went on to talk about the offshore element, which again is sort of surprising, I suppose, in as much that we were particularly here to discuss CPOs, but again, it was introduced, so I think it's relevant that it's brought up. I don't actually understand the entire derogation philosophy, which to me is just a relaxation or a diminution of rules, laws, standards and things. I'm failing to understand how that can be approved by any government or ministers. I think the time element, we started off about talking about prematurity. And this whole thing just seems to be elongating, and therefore I have no sort of visibility of when it's all going to come to pass and when the first kilowatt is brought ashore. But I think I'd maybe like to come back to these later on, but I think for now that's all I've got to say on the fact that the wind farm has the offshore element of the wind farm has not yet attained Scottish ministerial approval. Thanks.
Thank you. We may come when we get to item 8 on the common themes discussion. Have an opportunity to hear more about the general implementation timescale, which is the last question you asked there. And I should also say I'm aware that in your objection, you've made a general point about what you regard as the unnecessary complexity of this multi-consent process that you find impenetrable. I think as I'll give you I'll describe you rather than you describe yourself as a well-informed observer. You don't regard yourself as an expert necessarily in these areas, but to someone who's looking in from the outside, you're finding a very complex, impenetrable picture. I think is perhaps a summary of one of the points you made in your objection.
I would agree. I don't know if that needs any particular comment now, but I think. Fundamentally, I think there is something entirely flawed with this entire process for thinking up, designing, creating, approving significant electrical infrastructure in this country, particularly when there's a sort of Scottish element, there's an English element, there's so many organisations, from Ofgem to the ECU to East Lothian Council to this body, so many companies involved. Quite frankly, people like myself have been lost and treated unfairly due to all that I have mentioned. I just think it's just hugely unfair, and I would like to take whatever opportunity I can to highlight these, because I don't think that there is, quite frankly, honesty about how difficult it is for members of the public to make meaningful comment and objection and enjoy participation. Participation is in every government publication that I have read, it suggests that the public should be involved at the very forefront, and that just ain't happening, folks. It's just not there at all. Thank you.
Back to Mr. O'Carroll. Do you have anything further as a follow-up to the question, the response to the questions you posed, or do you want to move on to your next, the next part of your issues?
Yes, thank you. I think I listened very carefully to what was said. I think the answers went somewhat beyond what the initial question was, but I think it's helpful because I was going to come to those anyway. So I think we then have had the answer that there was one deadline missed, but that it wasn't the only one. There's other routes to market, there'll be other possibilities, and an annual process that's been missed. So I got that from Ms. Edwards. I suppose then, and I don't want to stray into submissions, but I suppose then the obvious point is then that we've lost a year on that particular front with that particular aspect of the overall consenting and process for all matters to be considered as part of this project. I suppose then it might just be a building theme with whether or not there is indeed prematurity, whether or not this has been a project that has been embarked upon too early in all the other bits of the jigsaw need to be put together. So I think in relation to that, I don't have anything further to add. You have those statements that have gone quite widely. I think the other point then, it might be helpful then if I just then go back to the Appendix 7 of the overview, the project overview that we've looked at. And I'm conscious that you do have another question about the interaction with England. I'll come to that later. But I do note that, as I said, it might be an idea to take them all individually, but certainly with regard to the ones that are based here in Scotland, whereby there's a Scottish determining body as well as the for all parts, is that we do have from that appendix numbers 1 to 8. We have, just take matters 1 through to 4. We've got the Section 36 consent. We then have the marine licence, which is also mentioned there. The other infrastructure marine licence and the marine licence sought again from permission number 4. And in each of those cases, we have the additional environmental information submitted in August of 2023. Now, obviously, it's slightly different from the Section 36 consent viewed in isolation, but it does strike me that, and perhaps a matter for comment by the acquiring authority, it does strike me that if you're looking at the AEI only being submitted as recently as August 2023, that we again have a situation whereby matters have been, still have some way to run. We have an acceptance by the acquiring authority here today that we have no indication from the Scottish ministers as to when these decisions will come out, and quite correctly so, because it's a confidential process once it's internal to ministers. So that's a concession quite properly made, I think, that we don't know what ministers are going to come out with, but we do know that the AEI was submitted in August of 2023. So I think just dealing with that one aspect, I think I would be interested to know what the acquiring authority have to say with regard to how recently that final part of that information was given to ministers for those separate consents, apart from the Section 36 consent, and therefore whether their confidence is justified as to whether they'll have the necessary consents in terms of paragraph 34 of the circular.
I'm happy to go back to the acquiring authority to answer that as they think fit. And I'm conscious the acquiring authority have various witnesses, but you're effectively representations and judge, so it's a bit of a kind of, we're having to be flexible in that regard. But I wonder, just on that question, is it linking to the question of sort of timings of when things were done and should have been done? And I'm conscious that the planning application was made something around April or May last year, decided, I think, on the 5th of December. I suppose my question from the sort of Dunlop perspective is that it's easy to criticise in a multi-consent process how the acquiring authority went about their business. I guess my question from Mr. Dunlop's perspective is, if they've got it wrong, what should they have done? What should the right order be? I would have thought it wouldn't be sensible to have a kind of linear process whereby you apply for one, and when you get one, you then go on to the second one. We may take a different view on all of that. Mr. Jimison's point might be that there should be more holistic approach taken, or more cohesion across the general decision-making process. But if the acquiring authority have got it wrong in terms of what they've done in timings terms, what do you say they should have done?
The obvious answer, I think, the one word coming from the word prematurity, the obvious answer is, if they were to do it, and that might be another question under that, but if they were to have done it, they ought to have waited later until they then sought to then put matters in train for the compulsory purchase of land. Because, of course, the override, and a matter that will come up later as well, the overarching thing is this, is that as soon as, and of course I'm representing an agricultural client, and of course there's a term known as planning blight, which is an interesting crossover in terminology. Because as soon as you raise the prospect of compulsory purchase, that has an effect on the landholders. Obviously, that's where the term comes from in planning terms. And when you do it too early, it means, therefore, the duration of that blight lasts longer. It's a matter of common sense. And so what I am saying, well, I think it's not the time for submission here, but obviously underlying the concept of prematurity is, this is a process that can be embarked upon later. So that's the answer to your question. And I note, for example, that the Cambois connection, the English connection, was that the application was submitted again July of 2023 for the marine licence. Oh, that's the Scottish one, the Scottish part. But the English part as well, also in July 2023. This strikes me, without having a detailed internal knowledge of the workings of government, but from a practitioner's point of view, it does strike me as having been quite recent, and therefore to have then embarked upon compulsory purchase of people's land as being premature, which is what we're talking about today.
Yeah, it's in fact it's blight, and I'm thinking about I'll ask the planning authority to comment on that as well. It's the issue of the kind of the planning blight. I'm thinking of planning consent that would last for 5 years, and the guidance for compulsory purchase orders that has an expectation that implementation will happen within 3 years. And I think, as we know, one of the reasons why the 3-year period is there is to minimise that risk of planning blight and minimise the risk that a compulsory purchase order is left hanging over landowners. What's your position, or your client's position, in relation to the fact that had an earlier application been made, that would have perhaps had a kind of similar effect once it's known that this application is being made? Or is your position is Mr. Dunlop wouldn't have suffered any blight until a compulsory purchase order was taken at a later stage? Would he not have known in July of last year that this was liable to be coming his way? I'm just interested in that interaction of when engagement should have started and when the compulsory purchase order process should have started, just to get a sense from my perspective as to what Mr. Dunlop thinks ought to have happened that was different from what did happen.
As you pointed out, I don't have my client here present today, and I'm representing him on the matters that we're talking about today as best I can. I think I can simply, all I can say is this, is that obviously when it is known that there's going to be compulsory purchase, then the matters such as operation and investment in particular are stymied because of the uncertainty that's thereby created. What Yes, and clearly when certain consents were lodged, having been properly informed and advised, you'd been aware that this was coming his way. But then again, it might not have been, because I think the other part that's stated within the written submission on prematurity is that, as you touched on yourself, is that if there had been an engagement, it could have been avoidable, and therefore wouldn't have been required to have the compulsory part of it at all. Voluntary agreement, page 4 of the hearing statement prematurity. I think that is my client's position as stated there, and therefore the entire blighting process, or the entire compulsory part of it, which is the least palatable part of this whole process, could have been avoided. That's fundamentally their position.
Yes, so just responding to a few of the points Mr. Carroll has made, I think it's easy to lose sight, sir, so far as his client's concerned, is that the principal permission required relates to the onshore infrastructure, for which planning permission in principle has been granted. Yes, it's accepted that there are other consents and licences and so on that need to fall into place ultimately, and that is a complex picture, as you can see from Appendix 7. But the circular, as we've emphasised in the written submissions and the hearing statement, the circular envisages scenarios where an acquiring authority needs to take steps to protect its position by pursuing a CPO, even though it doesn't have everything it would ultimately require at the point of promoting the order. Now, in relation to the point that's been taken about the submission of additional environmental information in August 2023, Sarah Edwards will correct me if I'm wrong, but my understanding is that that very much related to pretty technical issues relating to the derogation case, in particular in light of the fact that Scottish ministers had indicated an intention to close sand eel fisheries, which related to one of the compensation measures that was discussed in the derogation case. So it's a very technical issue, and for the reasons that she's explained, there are issues that no doubt are being given careful consideration by Scottish ministers and their advisers relating to that aspect.
Yes, and I would just also say that the reason why the submission was in August of 2023, we didn't actually receive the formal request for additional environmental information from Scottish ministers until May of 2023. So that only gave us 3 months to respond to, as we've just outlined, technical points relating to the compensation measures, in particular the sand eel closures, and again involved sort of further engagement with key stakeholders on those points and discussions.
Now, sir, just to respond also to the point which I think Mr. Carroll's making about the delay, as he would see it, in implementing decisions or reaching decisions. I wonder if Mr. Bell might want to comment on the political landscape as he sees it in terms of the pressures that now apply to Scottish ministers.
Yes, sir. I think this will relate again to the matter of the most recent Climate Change Committee report, which we will cover. But this whole issue was foreshadowed in the other Climate Change Committee reports, which I've referred to in my topic paper, and that pressure has been building. If I can just give you a couple of references for your note from my topic paper. The first one is paragraph 2.3.11, which is I'll abbreviate it to CCC for speed, the CCC report to the UK Parliament, June 23, that's CD 006.010, and at my paragraph 2.3.12, you can see the quotation there where the CCC comments on the UK position, and they refer to what's called a nationally determined contribution, which is in effect where the UK needed to be by 2030, which was 68% reduction in emissions, and we know that the Scottish Government position was 75%, and the CCC state that that achievement for the UK is increasingly challenging. And then further down on the same page in my topic paper, at paragraph 2.3.15, refer there to the next CCC report of January 2024. That's to the UK Parliament. And at my paragraph 2.3.15, again, the CCC is noting what they term a significant delivery gap there. And the report that we'll come on to talk about is the March 24 CCC report, which talks about the 2030 target. So there is undoubtedly pressure being building at the political level, and that has come through in the statement that Mr Mackay referenced from the Cabinet Secretary that we'll come on to talk about shortly. Thank you.
Lastly, sir, just before you want to have your break, your morning break, sir, might be useful to hear from Mr Hamilton, who will be able to give some additional information about the ability to implement within 3 years the CPO, even though the primary offshore consent is still awaited.
Thank you, sir. In relation to the 3-year period, Circular 6 of 2011 refers to that at paragraph 32. And that 3-year period runs from the date of confirmation of the order being published. And in the written submission for the acquiring authority, Chapter 5, which begins at page 21, I refer you, sir, particularly to paragraph 5.4. And, sir, you will see that it does state that the authority is satisfied and submitted Scottish ministers can be satisfied there's a reasonable prospect the order will be implemented within the 3-year period, because the grid connection dates which have been offered to the acquiring authority are currently for 2026 and 2027. Those are the dates at the Branxton substation. And further, the contract for difference, which was referred to earlier by Ms Edwards, although allocation round 6 has now been missed, it would be expected that the delivery years for allocation round 7 would commence in 2028. So, given the construction timeframes, most likely the order would need to be implemented within the 3-year period.
I suggest we take a break just now, unless you want to come back in any particular point of that before we.
Sorry, I just want one other point. It's just basically in relation to your own question, and that is that if I could refer you to paragraph 2.9 to and 2.10 of the hearing statement on prematurity with regard to what might have happened had there been a different scenario, rendering the requirement for the compulsory purchase to be fully. Thank you. That's all I wish to do for that. Thank you.
Okay. Should come back.
I was foreshadowing the possibility of going through each of the 16 separate consents that were required there, but I suspect that we've kind of gone through all those in the round, and you've had the evidence you require for those in the general, because the points are clear enough that there are a number of consents that do require to be obtained as part of this, and the interaction, therefore, with the promotion of the compulsory purchase order. So the other matter then that you've asked me about earlier, sir, is covered in the response to written submissions by Dunlop's as objectors, and this then relates to the Cambois, the English part of proceedings, the English part of the scheme, which we've already touched on as well. And with regards to what you heard, the three tests, the tests applied, the progress has been made with that, and what's required down south. So really the point that remains then, having heard all of that, is what's then stated in the response, which is making the point that we're dealing with obviously a truly vast offshore scheme, 4.1 production energy, but that nearly half of this is going to be part of the connection from England. The point that's been made, and the point you've already touched on, is that this is something which isn't before this inquiry. So, in a sense of whether or not what part is in your overall consideration is then given to you second hand. It's not part of this inquiry before you. And it is a significant part of the overall proposed generation from the Berwick Bank scheme overall. Now, what has been suggested would submit to correspond with an annex statement, which is email the 1st of December. I'm sure, and it's also been referred to in from the acquiring authority. So, is that not only do we have for this acquiring a series of consents, but also amounting to a substantial portion of nearly half of the overall generation proposed. So, what is being stated by the objectors is that this has a bearing on the overall public interest in the scheme. Now, clearly, as Mr. Bell's evidence will no doubt be stated before you, and clearly his topic paper is all interest in having from renewable. It has a bearing overall the overall public. It's stated by the acquiring authority that looking at the terms of the email of of course. I think the easiest thing would just be to read out the terms of the email, to read them out in full, which I think is sort of been pulled up on for not doing that in full. So consent to sort for 4.1 gigawatts, up to 3 gigawatts is to be exported. Proceed, and assuming to proceed, the acquiring authority would know the ability of the
by Dunlops, does that mean you think the weighing of the public interest means there's a sufficiently adequate doubt as to whether the whole scheme north of the border would proceed? Or is it that you think the scheme north of the border might be of a smaller scale, even within the Scottish scheme? And that plays into some of the arguments about excessive land take. Or is it both? Or is it simply a question you're posing that you want the acquiring authority to answer?
Yes, I think the difficulty is that the acquiring authority hold all the cards. I mean, this is just so apparent, so clear, and I think Mr. Jemison's articulated it as well, is that they're the ones that know what is being put forward. They're the ones that have all the technical expertise, and they have a bank of experts all arrayed against people that don't want the matter to proceed and affect their land. So it's very hard to therefore provide any detailed statement as to what it is they should or shouldn't do as part of their own business in generating electricity. But what it is being suggested is that these are matters relating not only to prematurity but also to land take, which perhaps we'll come on to later, certainly at the inquiry session. But that then is a matter that all objectors can do is to raise the question and ask for it to be justified, and that's what we're asking for.
Yes, but assuming Mr. Carroll accepts that it to be justified in the policy context, in particular Circular 6 of 2011. And on that basis, sir, the theme which he is developing, the general response is the same one as was provided this morning, that when one properly understands what the circular anticipates and expects, then the submissions that have been advanced by the acquiring authority explain why they expect that those barriers can be overcome, and have some confidence about that. In relation to the more specific point about the dependence or relationship between the Brankston connection and the Camas connection, I can ask Edwards on this, please, and just explain the point that's made at paragraph 3 of the acquiring authority's rebuttal hearing statement, which is that the Brankston connection is not functionally or financially dependent upon the Camas connection.
Yes, thank you. Thank you, sir. In response to that question, the main focus, the section 36 will stand in its own right as a consent for the offshore wind farm, and that is for the generation and the operation of that offshore wind farm, and that at the moment is for approximately 4.1 gigawatts. The Camas connection and the Brankston connections are, and the planning consents associated with those connections are linked to the grid connections that we have been offered in those two locations. If, for whatever reason, the Camas connection didn't exist, we would look for another grid connection elsewhere. I think it's important just to flag that we originally did have a later grid connection, an additional third grid connection at Brankston, which would have been a later connection for us, and then we were offered the Camas connection for the 1.8. And the reason why the project have proceeded with the Camas connection for the additional 1.8 on top of the 2.3 that we have at Brankston is that enables us to connect the full capacity of the wind farm, which is subject to the section 36 alone, by 2030, which at the time obviously was in alignment with government policy and the targets for achieving 75% reduction by 2030. And that's the position that we took.
I'm very grateful to understand that Cambois is actually pronounced Camas. I think is that correct?
It is, yes. Thank you.
No, sir, just again, possibly to repeat the point made this morning that yes, Mr. Carroll, on behalf of his client, is entitled to ask the question and seek a justification, but in doing so, there's not evidence being provided to the inquiry that suggests there's a good reason to shift the Acquiring Authority from its belief that these issues can be overcome and that the consent
in the suggestion that they're not necessarily linked or as linked because the acquiring authority have a kind of plan B effectively, or could develop a plan B. Now that's also speculative as might be suggested, and it's speculative because you have your plan A. But it is still the position that even if there were a refusal from Camus, would I say, describing it as, then the question in my mind would arise as, what can you say about the prospects or likelihood that this can remain or be made viable in terms of matters within the jurisdiction of Scottish ministers?
Yeah, the project would remain viable on the basis that the Section 36 would still stand, that consent for the full 4.1 gigawatts would remain. And the Camis connection consents that we're talking about is to facilitate the connection to the grid at the Blythe substation. Our grid connection at Blythe would also still stand. So we would just look at alternative solutions there in a scenario where, for whatever reason, the Camis consents were not granted. We consider this to be highly unlikely, but yeah, they are. It would not impact at all the Section 36, and that would remain as a standalone consent for the offshore wind farm.
One of the complexities in all this is, of course, the fact that there's an interaction with the position south of the border. I mean, it strikes me, and I'd welcome Mr. Carroll's view in this, if there is a concern about the cumulative effect, and the acquiring authority say there isn't, if there is a concern about that, I am mindful that the powers to grant these orders are reserved powers to Westminster that are simply executively devolved to the Scottish Parliament. And so it would, in theory at least, be possible that all of these matters could be decided, at least as far as the Secretary of State is concerned, if not Northumberland County Council. These matters could be determined by reserved bodies acting north of the border. Now that, I suspect, would come into the category of being politically very undesirable. Is it, as far as you're aware, Mr. Carroll, is it the view of the Dunlops that it would be better for all of these matters to be resolved by one deciding body? And it can't be Scottish ministers, because they don't have jurisdiction south of the border. Devolution is asymmetrical. But would your proposition be that all of this should actually be decided not by Scottish ministers, but by UK authorities as ultimately a reserved matter?
Thank you. That's a very interesting point, actually, and to be absolutely candid with the inquiry, that's not something I'd come here prepared to argue. I like the sound of it. I do very much like the sound of it, and it would be very, very glib for me to sit here and say, yes, actually, it all should be a reserved matter to be dealt with by one UK authority and not one with a reserved input. I haven't come here. That doesn't form part of our statement of case, and I don't think I'm quite in any real conscience can put forward that, however much I like it.
Apologise. It just has struck me because, as I say, devolution is not symmetrical, and these are only powers that are lent to the Scottish Parliament, to Scottish ministers to determine these matters. They have no legislative powers to legislate in this area because it is ultimately a reserved matter and would fall to them. But, I mean, Mr Mackay, I don't know if you want to say that. Again, equally, just as I hadn't really given any warning to those on my right, I've given no warning to those on my left either.
Only that there's no easy way out for you, sir. You're still going to have to report to ministers.
Well, no. I'd still have to report. The question as to whether it's something I would suggest. I mean, it's in political terms. I suspect in the current or indeed any political environment, an unwelcome suggestion. But as I say, sometimes you have to make unwelcome suggestions. Okay. All right. That's helpful. Is there anything more that we wish to address, Mr. O'Connell, principally on any other of these matters with the prematurity, or has that exhausted us?
I think
from those topics.
I think we have. I think I've felt that I've put before the inquiry everything I wanted to say about the question of prematurity.
Okay, right.
And further to that, actually, I think that's the only matter on which the Dunlops have a locus to appear in terms of the hearing sessions.
Absolutely. That's very much the case. I'm conscious that my questions that followed from this, the questions I have about the length and duration and the right procedure, although the Dunlops have not made any representations, I am also conscious, and I'm going to ask further questions before lunch, and you're perfectly welcome to sit and contribute or listen to them, just to get a little bit of further information and assurance as to what the intentions, what the plans actually are at the end of the 35-year consent, if it were granted. Now, it may well be that it is renewed at the end of the 35 years, but none of us know that. It may be the case that it's some considerable time away. The world may have changed enormously, and these sorts of discussions we're having about wind farms, we may be doing completely different things at that point. The reason I ask the question, and it's particularly actually for landowners who are affected, like Mr. Dunlop, if the substation ends up being built on what is at present his land, if the stage is reached 35 years down the line where it is reasonably obvious that actually there's going to be no continuation for whatever reason, either because it's likely to be refused or because the world has changed and there's not going to be the use of wind farms of this nature, and if the acquiring authority are sufficiently sure that that's the case, that they start thinking about demolishing the substation that we were built if this consent were granted and were progressed, what's going to happen to what was Mr. Dunlop's land? And so one of the questions I think I'm going to be asking, and I say this because this is the one issue which there is an interest for him, and in particular those whose full land is being taken, what is the position of the acquiring authority? And I think they have lodged some other documents in relation to Critchell Down rules and the like, so maybe Mr. O'Carroll, you have an interest in hearing at least some of the answers to these questions, even if not contributing towards them. But actually, before I go on to that, because I think that is the next issue we need to go on to, I'll maybe turn to Mr. Jimison. Before we entirely leave the question of prematurity, and without prejudice to what you're going to say at 2 o'clock, is there anything more you want to ask or say in relation to this discussion on prematurity in all its various forms?
Thank you. Yes. Regarding prematurity and some of the things that we've heard, some of which I can't pretend to understand, some of which I do understand. One of my major issues is the entire decision-making process around the decision to create a new grid connection point at Branxton and all the infrastructure that entails. Now, I've got a bit of an issue with the way I believe Ofgem have conducted themselves in their consultation with regard to decision making regarding Branxton. I don't think that was at all clear, open, available, accessible. Quite frankly, I think it was a shambles. I do appreciate then that the substation at Branxton, the grid connection point, is not a construction by the acquiring authority. However, I'm keen to understand whether or not Berwick Bank Wind Farm fails or succeeds in its ambitions if Branxton does not happen. Because as yet, Branxton has not, as far as I am understand it, been wholly approved by Ofgem because they haven't seen some financial case that is due. And moreover, Branxton will then need to go to East Lothian Council for approval, which, based on recent involvement with that fine body, I have no doubt that it will just sail through. But regardless of that, I think I understand at the moment that the acquiring authority and others are proceeding at risk, if you will, because the decision to construct, approve, finance, whatever, Branxton substation has not yet been made by anyone, fundamentally. That's all I've got to say on that, but I will like to come back on certain other points.
No, that's fine. I'll maybe look to the acquiring authority to respond to the questions in relation to Ofgem and the council. I actually had a related question which I touched on. I think it's maybe perhaps appropriate to roll this together, and that's the fact that an SPD and SPT are maintaining their objections right now. They say they're hopeful that by the close of this oral examination they may not be objecting, but they are as of present and maintain the objection. So can I add to Mr Jimison's points about Ofgem and the council, and just maybe ask for a response to the question of what would happen if the position was that agreement could not be reached with Scottish Power in relation to the Branxton substation?
Checking who the best person to answer that question would be, sir, probably Mr Hamilton in the first instance, but if Sarah Edwards or Paul Damber want to contribute, then
Thank you, sir. The position at the present time, as you stated, is that Scottish Power haven't come to a formal legal agreement with the acquiring authority, but I think they expressed that as very close. I'm not sure that was their exact words. If one was not reached, however, at the moment, Scottish Power are not the landowner at the Branxton substation, and that is why the compulsory purchase order has been promoted. Now, there is reference in chapter 3 and 4 of the acquiring authority's written submission to the possibility of transfer of land to Scottish Power, being a body which has compulsory rights. And it would therefore be the acquiring authority's position that the substation is more than likely to proceed on that land, at least in terms of the land available. As I understand it also, the Scottish Power substation is currently before East Lothian Council. An application for planning permission has been made, and that is currently going through the statutory processes. I'm afraid I don't have that information to hand, but others may be able to comment, sir. It has, yes, sir.
A consent process, as the name implies, if consent is required, consent can be refused. That's the nature of these cross-conditional aspects of things. And nobody's suggesting there should be 100% guarantee. So I suppose it is that question of where that balance lies of the likelihood or prospect, or reasonable likelihood of prospect, and that I think would be consistent with the circular.
Yes, but so you're not being asked to put a percentage on the prospects. That's not the function with respect that you have this inquiry, and it's not what the circular expects. The circular relates to the position of the acquiring authority, and for the reasons that's been explained in numerous ways in numerous documents, they have they're satisfied. All of the pieces of the jigsaw will fall in due course. It's acknowledged that it is a jigsaw, but that's just the nature of the beast, so to speak. But I think Sir Edwards might want to come in to just clarify just the expectations in relation to the substation, albeit it would have been perhaps helpful if Scottish Power were here to speak to themselves. But insofar as the acquiring authority is concerned, if she has any observations now, would be a good time to contribute.
Yes, thank you, sir. It's just to clarify that obviously Berwick Bank was awarded the grid connection by the system operator at Branxton on the understanding that we remain of a view that there's a reasonable prospect that the Branxton substation will be constructed, and we understand that the identification of that substation was part of a process that the system operator follows robustly for all of their grid connection locations, and that is how we arrived at the grid connection offer that we received, and that other projects have also received grid connections, which I understand Mr Jameson was alluding to as well. And so, the position as the acquiring authority is that we are working with that information that we have been provided and that grid connection that we have been provided, and we remain of the view that there is a reasonable certainty that that grid connection and the Branxton substation will be consented for that connection to be facilitated.
And Mr Gibbons, do you have any further questions? You've heard the answers, whether they satisfy you or not, I don't know, but you've heard the answers from the acquiring authority on those matters.
Thanks. Yeah, I'm satisfied with the answers, but again, the acquiring authority seems to accept that, in my words, they are progressing at risk because the substation is not yet built. You suggest there is a high likelihood of it being built. I probably believe that to be the case, despite the vast impact upon myself. Why I'm here to, again, I do appreciate I'm not here just to talk about Branxton substation because it's not your substation. But as far as I'm concerned, everything emanates from and to Branxton. Therefore, it is a significant part of the entire picture, which is an issue that I want to build upon and go back about the fragmented way the entire landscape has been affected and will be affected in the future. Thank you.
Well, I'm conscious that one of the issues there is very much, as you say, that the risk lies with the acquiring authority, and in some circumstances that might be the end of the matter. But in a compulsory purchase order, and I know you're not a landowner, you're not a statutory objector, but in a compulsory purchase order, nevertheless, there are impacts on people like the Muffets and the Dunlops, whose land would be taken from them in those circumstances. That's why I'm particularly keen to get a real understanding of the risks. So the risk is with the acquiring authority, but that, in my mind, is not the end of it. That's not the only factor, because in a compulsory purchase order, it's the state taking private land against the wishes of the various objectors. So I think it's really important that I get a really clear understanding, both of what you're saying, where you're coming from, but also what the acquiring authority are saying. Mr Mackay.
For your notes, sir, and for information, the Grand team has, according to the information on the ELC planning portal, determination of the substation, Branxton substation should happen by 10th.
Sir, I would add that the acquiring authority is acting in accordance with the grid connection agreements in place and the procedures therein for any changes. And in addition, the process we're following, we'd consider to be in line with standard industry practice.
summary perhaps across the various areas. I mean, this is largely covered, I think, in the documents about the various bits of uncertainty, one of which is the position beyond 35 years, particularly where actual land is taken as opposed to access rights and cable rights and the like. The other are circumstances where you know in advance that the rights are going to be temporary, and it includes a lot of rights around construction and around, I think, the temporary road and temporary access of the A1, and other scenarios where land is included within the order, but it might turn out that it's too much. So they're the three different categories that are in my mind. And again, I'm happy if you refer to the written documentation, because a lot of it is covered. But if you want to just summarise again your response to these various points, what is to protect the landowners who are affected, where it turns out, through any one of those three sets of reasons, the land take has become excessive, either because of the elapsing of time or because of a change of circumstances.
Thank you.
Thank you, sir. Again, I would refer to chapters 3 and 4 of the written submissions, which I would propose to take as read. I think of course, sir. So if I can perhaps divide it into three scenarios. The first is where the order already provides for rights to expire after a defined period, or temporary rights. This is found at paragraphs 4.2 to 4.7 of the written submission. The second would be where the order provides for permanent land take or rights, but before the order is implemented, it becomes apparent that land is not required. And that's dealt with at paragraphs 4.8 and 4.9 of the written submissions. And the third scenario is where the order has been implemented, but it is subsequently considered that the land is surplus. And this is considered at paragraphs 4.10 to 4.13 of the written submissions. Now, if I can take you, sir, to that, rather than read out the written submissions, perhaps to summarise what is there. In the first scenario, so that is the temporary rights, the acquiring authority obviously wanted to minimise what was required permanently, as far as reasonably practicable. And so there are two types of right in the order, which are firstly drainage rights, and the second is construction, compound and access rights. And those rights will expire 5 years after a defined period, which is essentially the vesting date under the notice after notice to treat. Now, the 5-year period will occur automatically. There is no need for any of the landowners to do anything. And that should allow for both construction and reinstatement within that period. The second scenario is where the order has not been implemented, but there would be permanent land take or rights. In that case, it would simply be the case that the acquiring authority would intimate that the rights were no longer required. In the event that it was of assistance to landowners, a formal document could be executed by the acquiring authority to the landowners in order to vouch that. And the third scenario is where the order has been implemented. In that case, the acquiring authority has indicated that it will seek to apply the Critchell Down rules, which are applied to Scotland through Circular 5 of 2011. However, it is important to recognise that the rules themselves, as applied through the circular, do have exceptions, some of which are applicable to the acquiring authority. Firstly, in the Electricity Act, Schedule 3, which provides the basis for compulsory powers for the acquiring authority, paragraph 4 of that schedule, which is, I should correct footnote 43 in the written submission, it referred to paragraph 4 of the 1989 Act. That should be paragraph 4 of Schedule 3 to the 1989 Act. That actually prohibits the acquiring authority from disposing of land without the consent of GEMA if that land has been acquired by compulsory purchase order. So that is a statutory restriction on disposal by the acquiring authority.
I looked at this afterwards. I think this is the bit where I saw a reference to the director.
Correct.
And I think the director role is this change.
It is now
function. Three, or possibly different legislation, I'm doing this a bit from memory, had done the amendment that had the effect whereby I couldn't find at first the reference to the director who had to consent before any differentiation happens there, but I take it that function is now vested in GEMA.
It is now vested in GEMA.
Okay,
perhaps I can come back to the specific piece of legislation that did that. One of the other things that is important to the acquiring authority is, of course, that the transmission assets will be transferred to an offshore transmission operator, or OFTO. Now, that is a requirement of the Electricity Act.
So is OFTO, is that effectively a quasi-public body in the same way that the rights of SSE are, although they're a private body, the exercise public functions? Are they effectively broadly an analogy organisation?
Yes, sir. They're a licence holder under the Electricity Act 1989. They hold a transmission licence, whereas the acquiring authority hold a generation licence. And for, among other things, competition reasons, transmission licence holders can't be generation licence holders and vice versa. So the acquiring authority cannot bind the OFTO to apply the Critchell Down rules, although one would expect as a quasi-public authority they would be likely to.
That's what I asked the question.
Yes, sir.
Could you contractually require to do that?
No, I don't believe so, sir, because the transfer to the OFTO is conducted by a tender process, essentially an auction, the rules of which are set by Ofgem. And one other exception, which is particularly relevant to the Ainsleys, that is the firm of GA and BB Ainslie, who asked for an undertaking in relation to Plot 27A that land be given back to them unburdened, is that, as I alluded to before, the Critchell Down rules except where a transfer is required to another body which has compulsory purchase powers, which in this case would include Scottish Power or Scottish Power Transmission, who are seeking to build the substation at Branxton. And so while the acquiring authority is seeking to apply the Critchell Down rules, it is important to recognise those rules envisage scenarios where, in fact, land will not be transferred back. They would apply, subject to what I've said, at the time. To take your point, sir, about what might happen in 35 years, in fact, the Critchell Down rules as applied through the circular have a specific exception, which is at paragraph 14 of Circular 5 of 2011. Paragraph 14 of Circular 5 of 2011. And it says, and it's at paragraph 3.28 of the written submissions also. And it says that the general obligation to offer back will not apply to agricultural land acquired on or after 30 October 1992, which becomes surplus and available for disposal more than 25 years after the date of acquisition. So, in fact, the Critchell Down rules state that they would not apply to that scenario. Now, of course, what I would emphasise in saying that is that what happens then will be up to an OFTO, who will own the substation at that point. But I can perhaps also draw your attention, sir, to the planning permission in principle, which has been granted. That's core document 001.012. And although the offshore consent is for a limited duration of 35 years, planning permission in principle is not limited to that 35-year period. It is a standard planning permission in principle which runs with the land. And condition 30 of the planning permission in principle requires a decommissioning and restoration scheme to be submitted and implemented if the development is no longer required for electricity transmission purposes. But the planning permission in principle recognises that may be a successor to Berwick Bank wind farm, and therefore a repowering scenario which would take it beyond the 30 years. Exactly. It's not guaranteed, but the planning permission, which is permanent, expressly foresees the possibility it will extend beyond the 35 years. Yes.
And just on that position, where Dunlop or his sons are pleading grandchildren maybe operated the farm in 30, 35 years' time. In the event that there were to be a decommissioning and everything was all taken down, would it be open, or would it be a priority given to the then owners of the interest of Dunlop to have first shot at getting the land back? They'll have to repay the compensation, presumably they get, but assuming that's the case, having the land taken from them, or would they have to, if they wanted to restore or recreate the farming business that's similar to what's there just now, would they have to effectively buy for that land? It would be sold in the open market and they'd bid for it and they may get it or they may not get it. Or would they be given some sort of priority in being able to get the land back that was originally theirs? And I say that because what you've said about the Critchell Down rules not applying to them.
Thank you, sir. Again, emphasising this would be a matter for the OFTO at that time. As it would fall out with the Critchell Down rules period, it is more likely there would be the Dunlops would need to bid for it. Even if the Critchell Down rules applied, though, it would be on the basis of essentially a right of first refusal at market value prices. So it's not simply handed back to them.
Yeah, I appreciate it wouldn't just be handed back. And as I say, they made to hand back the compensation they got if they got the land. What you say is exactly how I'd interpreted your submission, and I just wanted, particularly Mr. O'Carroll here, he's heard what's been said and noted that in the event of this scenario arising. But what you're saying is exactly what I understood you were saying in your submission, that the then owners of the business, if they were wanting to reacquire the land in this scenario, would have to bid for it, as opposed to being entitled to acquire it under an application of the Critchell Down rules. So thank you for that. That was the issue that was in our mind. Having a note past you just now.
Sir, if I can just clarify for noting purposes, it was Section 3.1 of the Utilities Act 2000 which transferred the director's functions to Gemma. Sorry, the Utilities Act 2000, Section 3, subsection 1, which amended the Electricity Act to include references to the director, now mean references to Gemma.
On this point, I'm conscious a little bit of the time as well. Is the question for Mr. Mackay on the decision to proceed, by way of way leave, of compulsory purchase rather than way leave. The submissions, I understand where you're coming from in terms of it being the choice of the applicant to decide what to do, but it was partly with the sort of the duration issue in mind. It may well be that the answer is different in relation to land being fully acquired as opposed to the likes of cable rights, which might be more appropriate to way leave. So I can kind of understand why permanent rights are taken back by CPO, but I wonder if you just maybe sort of summarise why it was decided, which in my experience is relatively unusual, is decided to proceed by CPO as opposed to a way leave right, given that a way leave would normally have, must have a limited time period, whereas CPOs are forever.
Again, sir, this is dealt with at paragraph 3.8 and the ensuing paragraphs of the written submission, and Mr. Hamilton's the primary author, so he can summarise for your assistance, sir.
Again, sir, just to summarise, rather than read out the written submissions which I've adopted, the primary reason was that due to the complexity of the construction project, in order to avoid any uncertainty about whether a necessary way leave would grant the appropriate powers, a compulsory purchase order was the preferred route. It's also relevant to note that at the time the order was promoted, necessary way leaves could not have been transferred to an off-tool, and so at that time there was no choice but to proceed by way of compulsory purchase order, although in the intervening period there has been a legislative change. Yes, indeed, sir. However, judged through the lens of what was appropriate in March 2023, a compulsory purchase order was indeed the only way the authority could have proceeded in a way which would have transferred the rights to an off-tool. Thirdly, is the point about visibility of the rights to third parties and on the land register. And while it may seem a relatively insignificant point, in fact, for future purchasers or possessors of the land, it may be very helpful to see that the rights exist when they're coming to purchase it. And in my own practice, I've had experience of someone who has purchased land and then accidentally dug into a high voltage line. So anything that can prevent that would be helpful.
On common themes, I think we've covered most of these matters. I think as I said at the outset, the question of adequacy of notice of the CPO, I think, has not been pursued by any parties. Tarmac had taken that point originally, but not done. The plot 10A is the only plot where the ownership is unknown, and I think the position was we certainly had requested through our DPA case officer that the intimation of this hearing was given by a way of a site notice at or around the vicinity of 10A, and I presume that was done at some point, so that if that order were to emerge, they could have been here today to have spoken about. We'll talk more about Brankston this afternoon when we come back at 2 o'clock. And I think you've also, at least in part, answered the question about the timings of implementation. I think that was another issue which also has arisen in terms of other answers this morning. My last question before we hope to break for lunch relates to one of the Ainsley plots at plot 27A. And I don't actually have it in front of me, but there was an explanation given. I think part of it actually relates to Brankston, of the other plots at 27 B, C and D, which I thought I could understand. There was a bit about the extent of permanent or time-limited use of plot 20. It's one of the Ainsley plots. I know they are not participating in this as a part of oral hearing, and as I say, I don't have the paragraph number in front of me, but I was wondering whether someone could just explain to me what the plans are for plot 27A Ainsley, so I can be just satisfied that on this temporary usage issue that there's no undue prejudice in respect of that plot. I'm not quite sure who's best to address that issue. Mr. Hamilton, with the sound of things.
Thank you, sir. Yes, sir. That plan should show 27A as an area of cable rights, and the order currently provides that the right to lay cable will be reduced to 8 metres from the cables post-energisation, which would leave the remainder of the plot with access rights over it in the way that the order is structured. But the use of those rights during the operational phase is expected to be infrequent. And so the practical burden on their land, and indeed any other land where only access rights apply, is limited and is not anticipated to interfere with current or reasonably anticipated uses of the land.
Which would this fall within? You mentioned scenarios 1, 2 and 3 on one of your earlier pieces of evidence. Which would be most akin to a best description for 27A?
It's not a temporary right, so it wouldn't be scenario 1.
Yeah.
It could be scenario 2, that before the order is implemented, when discussions with Scottish Power come to a point where there can be certainty over the design, if that occurs before the order is implemented, it would be possible to state that the land will not be required then. Alternatively, if the order has already been implemented, but the design is then finalised, then the Critchell Down rules would apply. At that point, it would be expected that the acquiring authority would not have made a transfer to the off tool, and therefore the Critchell Down rules would apply. Correct, sir. It's very likely that will be known during the construction period or prior to the construction period, because the Branxton substation is, of course, an essential component of the acquiring authority's route.
That's helpful. Thank you. Thank you for that. Okay. I didn't have anything else in terms of the common issues from this morning. Maybe before I ask you to comment, I'll just maybe see if there's anything more that anybody wants to say about those, either from Mr. Carroll or Mr. Jimson. No, at this stage, before we break for lunch at least.
Sir, I just want to clarify that I've now the inquiry at this hearing session in relation to prematurity, and this afternoon will be given over to Mr. Jemison, so I will not be appearing tomorrow. That's my understanding. With regard to... Right, thank you. And in relation to Wednesday, however, I indicated to the hearing earlier on that Mr. Dunlop, Senior, would not be able to appear. However, I've now been given updated information, and it seems he will, after all, be able to appear. Thank you. Thank you very much. I'll see you on Wednesday.
Yes, sir. Just two matters that Mr. Carroll may or may not have been interested in, but there was discussion earlier, as you know, sir, about derogation schemes and the offshore wind farms in England which had been consented. Mr. Paul Danborough has noticed actually that on Friday consent was granted for a Scottish offshore wind farm involving a derogation case. I just wondered if he'd be able to provide some summary information about that.
Presumably complementing Mr. Bell's evidence, this is not the Canis one, but it's analogy, presumably what Mr. Bell said, that there had been other examples of grants south of the border with a derogation. It's just to complement that point.
Indeed, but in a Scottish context, sir.
Okay, that's fine. Yeah, thank you, Mr. Amber.
Yes, sir. I just wanted to highlight that the Greenvolt project was given its Section 36 consent on Friday. Greenvolt is an offshore floating wind farm project in Scottish waters. Very timely. Around AR6 on Friday it was given consent, and it's the first one of its kind in Scottish waters that has a derogation case to support it.
Yes, sir, and the only other point was that on your list that you gave us at the start, one of the points was about engagement and lack of information, and maybe you're happy with the extent to which that's been discussed, but if you did need any more information, either about more generally about the efforts made by the acquiring authority to engage with members of the public, Mr. Darnborough can speak to the content of his topic paper, and more specifically, if there are any questions about engagement with the Dunlops or Mr. Jameson, then Mr. Hillis would also be able to assist. But it's really just if you felt that that was something you wanted to go into any more detail about.
I don't know if Mr. Carroll and I speak to you because we could come back at 2 o'clock and do this. I don't want to hold you up by asking you to come back at 2 o'clock on something you may have a relatively little interest in. I was certainly reasonably satisfied with the papers before me in terms of the issues arising on questions of engagement. And I'm also conscious that since the original objections were made, nearly a year has passed. There has been a potential period to continue that engagement, even if it had been wanting previously. But would you feel that there would be some benefit hearing from Mr. Darnborough just now, or are you satisfied that the subjects are sufficiently clear to me?
I think the subject is sufficiently clear, and in particular in relation to the position at which an agreement could have been reached by earlier agreement, I've already addressed you on in relation, wrapped up the question of prematurity. So if Mr. Darnborough wants to give evidence, then that's a matter for him, but I don't require anything further. No, thank you.
And then we can start then with Mr. Jimison after that, and then take the afternoon from there, and that'll let Mr. O'Carroll go and continue either other business or preparation for Wednesday. Okay, so we'll now adjourn until 2, and as I think soup and sandwiches are arriving at the other end of the hall. Thank you. Good afternoon. Good afternoon, ladies and gentlemen. We can may make a restart if we could bring ourselves to order. And before lunch, we would mention the possibility of Paul Darnborough making some further comments in relation to engagement. Before he does so, there was something that I realised I hadn't asked. Again, in relation to one of the objectors who are maintaining at least part of their objection but are not participating in the public sessions, and that is EDF, who had lodged an initial objection. And this is also on the question of prematurity. And in their original letter of objection of 21st April 2023, they had indicated that ENGL has no objection in principle to the project, but objects to the order on a number of grounds. Ground number 1 was the point of prematurity. The order is premature on the basis that the onshore and offshore consenting processes for the proposed Berwick Bank wind farm and associated transmission infrastructure have yet to conclude. As such, there is currently an impediment to delivery of the project, and the need for the rights proposed to the order has yet to be established. I'm assuming that your general answers of the acquiring authority are of equal applicability to the EDF objection, but just for completeness to confirm that.
That's right, sir.
Okay, that's fine. And we'll maybe just invite Mr. Darnborough to give his evidence in relation to engagement, which may actually be of some relevance to some of the points raised by Mr. Jimison. It will come to his objections just when we formally start that bit of the afternoon. Thank you.
Thank you, sir. Good afternoon. I really just wanted to take some time to explain some of the consultation that we did on Berwick Bank, particularly around my involvement, which was in the early stages of the project, around site selection and the routing. And I'm just referring to my topic paper, or I should say my co-topic paper with Conor Manning, which is the routing and siting topic paper. And in section 2.2 in particular, we summarise the general engagement that's taken place on Berwick Bank. There was 4 rounds of public consultation covering both the offshore and onshore, so we treated the project as one. And these events were done during COVID, so it was quite challenging actually to be able to do it. But we did have events in the Berwick Village Hall where we could speak directly to local residents on all the matters that we were engaging on. So we took a lot of feedback away, and those events were very well attended. I think there was over 70 people at the first event that we had. And there was presentations, boards, display boards, which showed the site selection process and the landfalls that we'd considered, the substation locations, and to explain how we'd refined that. And so it went from presenting that information in the first event, and then at the second event, how we'd arrived at our preferred locations for the landfall and the substation and the route in between. And I guess this information is also documented in Chapter 4, which is the site selection chapter of the environmental impact assessment. So there's a more detailed explanation in there, but I just wanted to sort of provide that summary to you. And I would also like to bring in my colleague Connor Manning, who could speak more about the specific engineering engagement.
Sir, from an engineer perspective, I'd like to just flag up that we have been proactively engaging with stakeholders, from commencement of concept design, throughout, as referenced in section 2.3 of the routing and siting topic paper, and also in section 4 relating to SPT, SPD, and also NNG. And I'll also make reference to the core documents 008.002.002, the Branxton Connection Landfall Onshore Cable Route and Substation Location Selection Technical Report. There's numerous references throughout that document in relation to the engagements, the outputs we received, and how we consider those in our design development process.
There were around 70 attendees at the initial meeting. It may be that people on my right can answer this question better than you, but what roughly is the population of Berwick? 120 houses. Thank you. Just to put a bit of context on the kind of level of attendees. Thank you. Although, 290 in the parish. Yeah. I'm conscious that there may well be people not living even directly in the village itself who may nevertheless would come into a meeting in that particular location. Okay, thank you.
No, sir. Unless you would want to hear from Mr. Hillis about any objector-specific engagement, for example, with the Dunlops, he can assist with that if you'd like some more information about that.
I think I'll probably leave that just now, given that Mr. O'Carroll is no longer here in terms of engagement with the Dunlops. It may well be, if there's any issues arising from what Mr. Jimison has to say, that we can bring Mr. Hillis back in at an appropriate point then. But I think we'll probably we can move on to the objections from Mr. Jimison, who I see has a number of other people are present and joined us this afternoon. You're all perfectly welcome. This is a public inquiry. It's not a public meeting in that sense, but it's a public inquiry, and I'm obviously very happy to get as many members of the public to come along and see this process and get an understanding of the sorts of issues that we're going to be addressing. But the main purpose for this afternoon session, which was originally set as a double session dealing with the objections from Mr. Jimison and outstanding issues from Scottish Power through Scottish Power Transmission and Scottish Power Distribution, is now going to be limited to Mr. Jimison. Scottish Power are not being represented at this session this afternoon. Their main interest would relate to the Branxton substation. They maintain their objections to the order, but they're not participating in the discussions today, and they're in ongoing discussions with the acquiring authority in relation to whether that objection could be withdrawn, but those negotiations and discussions have not reached conclusion as yet, so they are still formally objectors but are not participating in this afternoon's session. So, from Mr. Jimison, who spoke a little bit this morning, but basically this is now your opportunity to make such statements as you think fit, and you've given notification. It's important that we have a process here whereby there's fair notice given to the acquiring authority of the sort of questions you're wanting to ask, the very broad headings of the questions you're seeking to ask. We may end up developing some of those themes in a bit more detail today, but you've given a set of 6 questions, I think, that you wanted to found your presentation around. So it's very possible that this afternoon may be a kind of combination of you saying what you want to say and asking questions, and we can identify, Mr. Mackay will identify a relevant witness who might be best placed to answer those questions. Now, in doing so, I'm really in your hands as to how you want to present your case. You have provided all parties to the inquiry with a statement relatively recently which has those questions, but I also have before me here, and you can feel free to refer to those, both your original email to the DPA case officer of the 11th of June and then a subsequent follow-up on the 16th of June last year, which predated the first pre-examination meeting. You also gave a statement and circulated in writing a statement for that meeting as well. So all of those documents are before me and are relevant if you wish to refer to them. You don't have to read them out again unless you feel there's a benefit for those perhaps on the table next to you, if it would be beneficial for them, for you to read any bits out of it. But please take as much time as you want in presenting what you want to say and asking your questions. But essentially, aside from that, the floor is now yours.
Thank you very much. Thank you very much, sir. Yeah, as you've said, I have prepared previously quite a lot of stuff that I've submitted and I've read, and I found myself in a situation where I'm firmly out of my comfort zone. I find this difficult. I don't find it overly comfortable, but I feel I have to be here because, quite frankly, I feel extremely hard done to by the system. Yep. I do not believe anyone has made it easy for me or others, although I appreciate I'm only here as an individual, so I'm not going to talk for anybody else, but that's another thing. But this has been an utter nightmare of mammoth proportions for myself, who lives right at the heart and the very centre of a whole load of this stuff. I'm hugely disappointed, as I say, by the system. Yeah. If I can pick out certain components of the system, I'd like to do so. I would like to take issue with the depth of and attention to detail paid in so-called engagement and consultation. Yeah. I've never felt at any event that has been conducted by the acquiring authority that I was participating in anything. Yeah, I've only ever felt I was being told what was happening. Yeah, which I firmly believe goes against government aspirations for public involvement. Yeah. I would have loved to have the opportunity to truly participate, to truly make a difference, to become involved. I'm actually from a civil engineering background myself. I used to be the development director at Edinburgh Airport until 3 or 4 years ago. So I do have a bit of experience in multi-million pound development. And I just think there's complete and utter failure to adequately engage and give people an opportunity to determine their future. Yeah, this has all been done to us, not done with us. So I'm afraid to say, please don't tell me it was the greatest of engagement and consultation, because I firmly don't believe it was. I think it's just been a minimum tick box exercise. And I would urge you, for what it's worth, if you're going to do it again, for other developments and other programmes and other projects, you need to raise your game on public participation and engagement and involvement. I think it's been pretty poor. I do believe you could have done a whole lot more. And I'm just disappointed.
Because of the way the engagement and indeed the process has been done, is undertaken, I feel that it has been essentially salami sliced into a whole load of discrete projects and developments by different operators and developers and approving authorities, which has created an opportunity for others to wash their hands of things. Yeah, and I'll give you a couple of examples. I mean, clearly, Branxton substation. Appreciate it's a Scottish Power thing. Yeah, however, your cables terminate or originate at Branxton, so there's a lot of overlap throughout this whole geographic area with the Eastern Link, Branxton, Berwick Bank, and many other projects that have subsequently come along by smaller developers, yeah, that have all just added to a feeling of complete and utter overwhelmingness to me as a resident, yeah, and quite frankly, utter impotence, yeah, to be able to influence anything, yeah. So I do actually have a huge issue with the way that the processes by which you guys earn your bread and butter and deal with on a daily basis is just not fit for purpose, as far as I'm concerned, when it comes to engaging with me, taking my input, me giving input. It's just a mess. Something needs to be done. Somebody needs to learn from this. I'm aghast that Scottish Government did not grasp the nettle and realise, or perhaps they did realise, that the magnitude of this thing should have been conducted in a whole different way. As I've suggested, it's a salami slice approach. We did hear previous issues that it is complicated. I understand that it's complicated. I get that. But just because it's complex shouldn't make that any more of an impact for me. Yeah? Systems and things need designed to be put in place to make it easier for me and others to understand and input or not be impacted. Yeah, we heard sort of a slight argument or a slight question this morning over the sense of it being a linear approvals process. Again, going back to my previous employment, I understand that linear processes are by their very nature, they're quite time consuming, yeah? And there's a lot of ducks to get in the row in various rows. But the earliest mention I can personally find of Berwick Bank Wind Farm goes back some 12 years, yeah? Now, I don't know who has been doing what for the last 12 years, and why we now find ourselves in this situation that it is relatively recent that this has all come to pass in EH42 1QT, which is my postcode. Yeah, there are very few people that live in our area. Yeah, and I think far better and individualised and tailored method could well have been carried out by not just the acquiring authority, other parties involved as well in the sort of geographic development area. You could have done a whole lot more. I would as I've said, I have prepared a number of statements over my involvement in this, which, again, I have to say, it's dragging me down. You know, it's dragging me down, having to sit for hour after day, reading thousands of pages of stuff. I shouldn't have to do this, yeah? I, with the greatest respect, would ask the reporter to feed back to Scottish Minister that this needs to be made easier for Joe Public, yeah? I can't do this. Others can't do this, you know? It has taken its toll for me to be here fighting, because I consider myself to be fighting, yeah, for my future, yeah, because I think all the developments, all the planned developments around about where I live, yeah, they are affecting me, will affect me, and I'm getting no recognition or acknowledgement of that from anybody. I'm just, quite frankly, getting ignored. Indeed, various planning processes, I do appreciate that this is not a planning inquiry, but I think, as we've seen this morning, we're kind of all over the place, and we're touching on lots of areas. I actually, from recollection, I don't think there was one voice of support for this scheme that was approved by East Lothian Council. I find that disappointing. There were, I think, from memory, 54 individual objections. There were 4 out of the 5 community councils all objected. And we've just found ourselves, again, being ignored, because I think East Lothian Council felt that they had no option but to approve it. Yeah, everybody gets the need for carbon reduction and what have you, but people need to be given a choice and answers and the ability to participate and influence that. We don't need to be told, yeah, because I don't think what has been derived is the right answer. A couple of months back, we did talk about, I was enabled to talk and others were enabled to talk about, as a small example, alternative locations for a major substation. At one point, I think the acquiring authority felt that that was my only beef with this entire thing. Well, that's not the case, you know. My beef is with the entire process, yeah. I did take the opportunity to submit a few ideas. I only did that because I was invited to do so, yeah. Those have subsequently been found to be in the too difficult box to pursue because of Office of Nuclear Regulation involvement or Nuclear Liabilities Fund or EDF involvement. And that is disappointing. But again, I would reiterate that if a far better and more holistic and controlled, I'll use the phrase planning process or master planning process, had been created and delivered 12 years ago, yeah, we could have been in a completely different position today. Because I just do get the sense that this is quite a political arena we're working in. We don't need to go again to talk about the Scottish Government abandonment of their latest targets, but clearly it is political. And I do fear that the political imperatives and what have you that everybody tell us are so important, that within that, people have been forgotten, communities have been forgotten. And again, that is just hugely disappointing. I do have a couple of questions. So I have no intention of rereading stuff that I've submitted previously. I would like to ask some questions of the acquiring authority based upon that. I have given you a heads up to them. Equally so, if opportunity exists or is desirable, I'm happy to have questions aimed back at me, because as I say, I want to participate, and I want to be able to say my piece, and I want to hear what you've said, and I want you to understand as best you possibly can why I am here today. I'd be surprised if you don't know why I'm here today, because I consider this development, of which your project is a component part, to just be hugely impactful on me and my neighbours. Yeah, but I won't mention my neighbours because I'm not allowed to. And I think you fail to recognise that. You fail to acknowledge it. You fail to address it. Others have failed to address it. Approving bodies have failed to address it. And my vain hope is attendance here today and perhaps tomorrow is that the reporter can take back something to ministers and say, look, this should have been done in a different way, could be done in a different way, needs to be rethought through, because it's just unfair. It's just unfair. If I could just jump in and ask some questions.
Do so, just a small point there. You mentioned about the putting forward of alternative propositions. I should just say, and for the record for today's proceedings, that from my perspective, you're not in any way wrong to have put those forward. I want to make it absolutely clear that there's no criticism of you for having sought to look at those alternatives. They were addressed in writing at the turn of the year, but I should make it clear that there's no feeling or sense from my part that you've done anything improper by putting those forward. You were entitled to do so. I just wanted to just put that on the record. For you.
Yeah, that's understood. I don't feel any pressure for that. And again, as I said, the only particular reason I did that was because I was invited to do so.
You did exactly what I invited you to do, I should point out.
So, as it transpires, and as I've said, without labouring the point, I think if there had been a more collective, more rounded discussion, debate, design, and analysis, we, the country, East Lothian, we could have got to a different answer. I believe that. But again, we've had that discussion, and for a variety of reasons, we've been told that that can't happen. So anyway, if I may move into just some questions. When this first came along, the opportunity to get involved in and object to these compulsory purchase order, I made efforts to become involved. Not because I'm a bad person, because I think I'm entitled to do so. I understand I'm entitled to do so, and clearly I'm entitled to do so by virtue of the fact that I'm here today. However, from my very first involvement, the acquiring authority has objected to my involvement in this process. And I'm intrigued why. I'd like to hear an explanation why the acquiring authority has objected to me being here, not just once, not just twice, but several times. So I would like to hand over that question either through the chair to the acquiring authority.
If there's been a number of questions, but I think it looks like Mr. Hamilton is.
Thank you, sir. This is dealt with in the hearing statement for the acquiring authority at page 23, paragraph 7. '23, sir. It is a short paragraph, so perhaps for the benefit of others, I can read it out. Mr. Jameson had the opportunity to object within the legislative time frame for doing so. He did not avail himself of that opportunity. The acquiring authority was, as a result, entitled to object to the late entry of a new objector. In any event, it is plain that no prejudice has arisen in circumstances where the reporter exercised his discretion to allow Mr. Jameson's objection to be received, although late, and Mr. Jameson has since participated fully in the inquiry process. And if I can perhaps expand on that slightly, sir, to say...
So, because that's a technical explanation, I think Mr. Jameson was looking for a more deep, a deeper understanding of the why as opposed to the what, if you see what I mean.
Indeed. The legislation sets out a time period for objections, which in this case was 21 days. Mr. Jameson's objection came out with those 21 days and was therefore late. And so the acquiring authority objected to it on the procedural ground that it came too late. The reporter has now concluded Mr. Jameson should participate. Since that ruling, the acquiring authority has entirely accepted that position, and Mr. Jameson has participated, and the acquiring authority has absolutely no issue with that and welcomes his participation.
And just to underline that point, sir, it's obvious from the number of witnesses the acquiring authority has here this afternoon that the acquiring authority really has sought to engage with the points that Mr. Jameson's provided. He's been treated in the same way as any other objector, in the sense that the acquiring authority has responded in the hearing statements, providing reassurance where possible, information where it's not. So his position has been very much taken into account by the acquiring authority during the preparation of this inquiry, and been taken very seriously indeed.
Okay, thank you. And just it's again of benefit to Mr. Jameson. When I was giving some thought to the question, I was aware you were out of time in terms of the 21-day period, but you had approached my office ahead of the first pre-examination meeting, and so it seemed to me there was no prejudice to the acquiring authority having you in from that earlier stage. What becomes difficult is if objectors come at a very late stage and there are processes that are complied with and documents are submitted and various things. So that becomes procedurally very difficult. It's not to place procedure above everything else, but I was satisfied because you had come, albeit technically late, you had nevertheless come before there'd been the first hearing that I had, and therefore there was no difficulty. And I think at that point there were 16 other objectors. It didn't seem to me that the authority were prejudiced by you being permitted to come into the process then. But obviously as the process progresses, it becomes harder to let new people come in because that ends up being disruptive to the kind of efficient carrying out of the process of the examination.
We sort of touched on this this morning, but perhaps now that I've got the floor, if you will, I'd just like to sort of discuss and investigate the timing of things. As we've said, this is a sort of fairly complex, multi-headed beast, consisting of offshore works, under marine cables, onshore works, grid connections, etc., etc. Each of which, much to my annoyance, seems to have to go through strangely different process of project approvals. In light of what we've heard this morning about Scottish Government targets being removed, rescinded, and I do understand that we did have a brief discussion about that, and thank you for the briefing note that I'll digest in bed tonight. I'm keen to understand that, you know, from today, as we're sitting here with a sort of best endeavours approach, when is it anticipated that the first light bulb will be illuminated, courtesy of Berwick Bank Wind Farm? And obviously by that, I mean, when are we anticipating all the 307 turbines to be built, or perhaps you're going to bring them online in a sequential manner? I don't know. Underground cables done, onshore works near where I live, connection to Branxton, overhead pylons corrected. How far away are we from that happening as we sit here today?
Yes, thank you for the question. So I can respond to that in terms of the timescales that we're working to. The main focus is the grid connections for Branxton, which are 2027, and in terms of the power coming online for the entire wind farm for the full 4.1, that will be sequential. It won't all the turbines will not come online all at the same time. But targeting sort of 2028 onwards for the first power, and the timescales that we're working to are to facilitate that and for us to be able to meet those grid connections in accordance with the agreements that we have for those connection timescales.
And just for the avoidance of doubt, can you confirm that those timescales are not essentially affected by the announcement about the 2030 interim target being set to one side?
Yes, that's correct.
If I could just press you a little bit further on that, please. Berwick Bank Wind Farm, i.e. the offshore turbines, are the mechanism by where you generate electricity. And you'll bring it ashore to Branxton, yeah, but it will go into the grid. You're suggesting you've got a connection deadline, or I'm not sure the phrase you used, but a connection timeline of 2027, I think you said, at Branxton. So the inference to me is that by 2027, Branxton substation needs to be built. And you need to have one or more of your turbines built offshore and a cable onshore, all within the next 3 years.
Yes, that's the programmes that we're working to in terms of the consenting strategy, and the approach that's been taken based on the programme is to achieve those grid connection dates.
With the greatest of respect, what you just said, it's a thing you're working towards. Yeah, you didn't overly give me any confidence that in the next 3 years, offshore turbines will be built, a 40-kilometre cable will be laid to Skate Raw, and somebody, not you, somebody will build Branxton substation in the next 3 years, i.e. by 2027 or within 27.
Yes, so we're looking towards the end of 2027 for the onshore grid connections that we'll have. And you're right, outlining all the work that needs to be done for that. But as I outlined previously, sir, the project obviously will be developed sequentially. We will not be able to build all 307 turbines at the same time. So the power will come on online, and we will be connecting to the grid with various, in a number of phases, so that we will, and the infrastructure will be developed in line with that phasing. So it won't be the full 4.1 gigawatts that are online by 2027. The actual, we have later grid connections, as we discussed earlier, for the Camis connection is 2029. So turbines required that will be connecting into the Camis connection will be installed later. But the programmes that we are working to are to achieve those grid connection dates at Branxton, which is the subject of this CPO inquiry.
Okay, thank you for that. Again, I hope you don't think I'm being facetious or rude in pressing you on that, but as a lay person, I find it quite an adventurous programme. In fact, I'm not just a lay person, I'm a construction professional, yeah. I'm doing myself a disservice, you know. I just find it quite adventurous that from where we are today to what you're telling me is that power will be generated by one or more of your turbines and brought to Branxton in the next 3 years. That's what I'm remarking upon. I can only go by what you've told me, so I thank you for that. From the first time a lot of us met, which met in person, was at a site visit. Well, it seems a long time ago. I have been confused about the interplay between SSE compulsorily purchasing land upon which Scottish Power will build, may build a substation. We did chat about it on site, and I remember distinctly that, in fact, Mr Hamilton actually came back with some written rationale later on, which, to be honest, I never fully understood. Again, I get the complexity of it, I get the fact that there's lots of interconnections and things like this, but I'm still slightly vague as to why SSE, the acquiring authority, want to compulsorily purchase the ground, somebody else's ground, not my ground, upon which Scottish Power will build a substation. I'd be grateful for an explanation.
Thank you, sir. To summarise the letter of 30 June 2023, which I sent to Mr Jameson and copied to your case officer, sir, the substation at Branxton needs to be built by Scottish Power Transmission because it's a transmission substation. And so, as a generation licence holder, the acquiring authority are not permitted to build or own such a station. In terms of why rights are being sought over the whole area, that's because at present the acquiring authority can't be certain where the substation itself is going to be located, and accordingly which way the cables will need to get into that substation. Now, as that design is refined, it is likely that it will become clearer that areas are not required, and that would then fall into one of the scenarios, perhaps 2 or 3, that we discussed this morning, sir. That's in relation to not proceeding with the order in those areas. And there has, in fact, been an example of that in the modifications which have been brought forward. One of which relates to Scottish Power. If Sir has had a chance to read the modifications, you'll see that a small area of land which was to be acquired outright is now being sought to be modified to cable rights only. And that's because, in line with Scottish Power's updated plans, it's now understood the substation footprint will fall into that area. So the acquiring authority does not want to acquire land where the substation is going to be, but it does want to acquire the rights to take its cable into that substation. So it needs to have the rights in that field to take its cable.
But later on, and I mentioned to both of you the reference to the plan that was given to me at the site visit in December. I take it it's the purple site there is the land to be acquired, and that's the one that will be subject to the modification you've just referred to. So this map is to that extent going to be slightly out of date. Is that correct? Yes,
that's correct, sir.
Thank you.
Thank you. So a general question that I would like your view upon is whether or not yourself, the acquiring authority, can you explain to me if you think I will be unaffected by either their proposals or their knowledge of other proposals immediately adjacent to where I live. And by immediately adjacent, I mean in the nearest 3/4 of a mile. I don't mean 6 feet away. I'm just essentially trying to gain a bit of acknowledgement that this is a huge impact on me. And therefore, I'm trying to develop understandings, routes, mechanisms, etc., where I can minimise that.
Could I ask, at the site visit last August, you pointed out where your house was. Could you give a rough indication of how far your house is from the Branxton substation, the current substation? That may help frame this question.
Yeah, I reckon my house is probably 150 metres to the north-west of the proposed substation. As I said in earlier correspondence, I cannot just put my finger on one small little aspect of the entire development in our area, my area. It is the Branxton substation itself. It is the acquiring authority's cables. It is the Eastern Links cables. It is the onshore works where they come ashore. It is the large substation immediately to the north of Crow Hill. This is a huge cumulative impact that nobody seems to be willing to acknowledge, address, understand, explain. There's a sort of people withdraw into their own little comfort zone to say, yeah, but that's not ours, that's somebody else's. You know, we're not building Branxton, we're building this, we're building. I get all that, yeah. I'm talking about the combined and cumulative impact on myself.
Sir, would it be helpful if I ventured a response? In terms of the impact on Mr. Jameson himself, those have been assessed by the witnesses who are present, and of those, Mr. Welsh and Mr. Leaper will in particular be able to hone in on that aspect. But looking at more generally about Mr. Jameson's point about the other development that he refers to, in particular the Brankston substation, it might be helpful, sir, to have before you CD 8.1.3, which is the report of handling to the Planning Committee, dated 13th November 2023. That's CD 813. I think 001.003. Yes, sir. Now, sir, Mr. Jameson was present and addressed the Planning Committee, but what I don't know is whether he actually had read the environmental assessment report and is familiar with its content. Yes, he's indicating he is. So I draw this to attention, sir, and to Mr. Jameson's attention in particular, because the report of handling, as you would expect, it summarises the officer's assessment of what the environmental information is saying, and it highlights any issues that the planning authority officers might have with the content of the environmental assessment report. So if you look to page 10 of the report, under the heading of environmental impact assessment, and just to read certain paragraphs, sir, the first paragraph says, an environmental impact assessment EIA report has been submitted with the application and has been duly advertised and consulted on. So obviously it's gone through the statutory procedures to allow members of the public to submit consultation responses on things like the impacts, the environmental impacts, but also on the discussion of alternatives included within the EIA report. And then at the bottom of the page, sir, the new paragraph begins, the EIA report informs that a cumulative effects assessment, or CEA, is a requirement under the EIA regulations. A CEA provides consideration of the impacts arising from the proposed development alone and cumulatively with other relevant developments. Cumulative effects are therefore the combined effect of the proposed development in combination with the effects from a number of different projects on the same receptor or resource. And then this is the bit I would ask you to, Mr. Jameson, to observe. Each technical chapter within the EIA report has undertaken a CAA. Potential developments within the technical assessment study areas were screened to determine whether there is potential for overlap of environmental effects with the proposed development, and therefore a potential for a cumulative effect to occur. Where there is potential for cumulative effects to occur, each environmental receptor was screened based on the technical expertise of the assessment team. The other developments factored into the cumulative effects assessment are the Eastern Link project, which Mr. Jameson referred to, the Brankston Substation project application, which is noted as being currently pending consideration, also Crystal Rig 4 wind farm, and another. So then, sir, you've got a summary provided by the officer of each of the relevant sections, or chapters rather, from the EIA report. And under the heading of landscape and visual, there is a sentence beginning about 2/3 of the way through that section of text, about 10 lines from the foot of the paragraph. It begins, where cumulative developments are visible from key landscape and visual receptors. So where cumulative developments are visible from key landscape and visual receptors, they would have limited cumulative interaction with the proposed development, or the cumulative effect would be minimal, short-term and temporary, substantially limiting their cumulative influence when considering the additional effect of the proposed development. So that was the summary of the position reported in the EIA report. And it's noted elsewhere, if you follow on to page 19, sir, that the landscape officer for the local authority essentially accepted the conclusions and the advice that was presented in the EI report. So for your notes, sir, that's foot of page 18 and the top of page 19. So with that context, sir, it might be useful to hear from Mr Darnborough and or Mr Welsh, just to confirm that so far as the developer, the acquiring authority is concerned, the cumulative effects of the projects that Mr Jameson has made reference to, insofar as they have the potential to give rise to likely significant effects, they were factored into the assessment in the EI report.
Thank you, sir. James Welch. I think to answer Mr Jemison's specific point about how would he be impacted, the cumulative assessment indicates that there would be no significant cumulative impacts, bearing in mind the acquiring authority was not responsible for the assessment of the Branxton substation. We assessed it as a cumulative development, but SPEN will undertake the assessment of that development in EIA terms. However, the landscape and visual impact assessment does identify significant effects extending out to approximately 1 kilometre from the proposed substation, the onshore works substation. And coincidentally, my understanding of Mr Jemison's property location is that he's just about at 1 kilometre or just beyond it. So there is potential from the landscape, particularly to the west of where he lives, for some significant landscape and visual effects to occur. I looked at that in more detail in my topic paper and specifically addressed the matter of residential amenity as well. And because of the location of Mr Jemison's property out with the blade tip, the development ZTV, there is no possibility for the residential amenity threshold to be reached as set out in guidance, because his property does not have a line of sight to the proposed development. And I would just add to what Mr Mackay said, that there were actually 2 cumulative assessments undertaken. One was set out in the EIA, and the landscape and visual section is in CD 2.1.8. Following submission of the application, the planning authority asked for a further update to be prepared to include the Branxton BESS project, battery storage project, and an addendum to the EIA was prepared, which is CD 2.8. And that also addresses an updated cumulative baseline, including the battery storage project as well.
No, I've got nothing to add to that, sir.
I do recall the documents, and I have a huge library at home now of documents. I genuinely, I'm just aghast, and I still dispute the denial that cumulative effects and what have you fall into the not significant category. I'm just flabbergasted by that. But I do, however, acknowledge that I have no line of sight to the substation that's proposed north of Crow Hill. I personally have no line of sight to that. I understand that. I think just a couple of minutes ago, when you were talking about the some of the assessment criteria for cumulative effect, you used the phrase short-term and temporary. By no stretch of the imagination is any of this building work, construction work, short-term. It's going to fundamentally change my life for the next 5 or 6 years, and I don't know where to go with that. I really don't. It was mention was made also regarding the planning officer's report and what have you, and myself and others having had the opportunity to object previously. I suppose, ladies and gentlemen across the table from me will be as aware as I now am that certain objections are viewed as non-material by the planning authority, and therefore, if I have a material objection, which I did, and I followed the process, a number of my material objections were deemed as clearly not having enough sway to get the planning committee to change their opinion. However, any objection that I have that is deemed as non-material, clearly the planning authority take no flaming notice of it. They just it becomes irrelevant to them, yeah. But it is not, however, irrelevant to me. So a couple of examples of quote marks non-material objections, yeah, are the reduction in my property value, yeah, which I believe will be significant. However, I cannot lay the blame wholly at the acquiring authority's feet, yeah, because there are plenty of other developers in the area, or that plan to be in the area. So I don't quite know where to go with it. I don't know, when I come to try and sell my property and I'm told that I ain't going to get what I thought I was going to get for it, what do? East Lothian Council don't want to hear it. Not sure if the acquiring authority will want to hear it. Or do I go to Ofgem? Or do I go to Scottish Power? Or do I go to the Braxbest developer? Or do I go to the solar farm developer? I am just fundamentally in the middle of a development hodgepodge, yeah, that I know will be used against me. Very clever people will continue to say, sorry, that's not us that's affected your property, that's them that's affected your property, yeah. I need a view, I would like a view, either from yourselves across the table, please, your response to a course of action that I should take, either directly with yourselves or via another route, to address my perceived, and it is perceived at the moment, I have acknowledged it is a perceived devaluation of my property. I cannot furnish you with evidence that my property has been developed, that my property has been impacted, because my property is not for sale. Yeah. However, it may be at some point. Yeah. So I'd like to get a view on whether or not the acquiring authority feels, acknowledges, accepts that there may be an adverse impact on my property value.
Yeah, I don't know if you want to or are able to discuss that in this forum. If not, because this obviously is an investigation, an examination into the compulsory purchase order, compensation matters are not within my remit, but that shouldn't detract my encouraging you to have a dialogue maybe out with the context of this this discussion, if appropriate representatives of the authority to seek to discuss with Mr Jimison the concerns relating to matters that may not fall within this remit, but are clearly matters of importance to him.
Yeah, that's noted, sir. And just to, I think, summarise the point that Mr Welsh was making earlier, if you look to paragraph 6.24 of his topic paper, if I can just report the words used there. It is accepted that travelling on the minor road network between Innerwick and Thornton Glen, or from the Thornton Loch junction on the A1, there will be views of the onshore works during construction and operation when approaching Sunnyvale that the LVA findings indicate as having the potential to be significant in EIA terms, which I think is what Mr Wells was acknowledging earlier. He's not pretending there's no issue. It's acknowledged. But this does not amount to a significant impact on the residential amenity at Sunnyvale itself. And the RBA guidance is then discussed in a bit more detail in his topic paper, paragraphs 625 and 626. So it's not Mr Welsh's position, as I understand it, that there are no likely significant effects. He accepts that, as you would expect with a development of this sort, there will be some. But it's now seemed accepted by Mr James himself. He doesn't have any line of sight visual impact from his own property. Nevertheless, the acquiring authority has asked Mr Welsh and Mr Leaper to consider the issues that might arise from the point of view of residential amenity, and for the reasons that they explain, that there's nothing really to say about it. Mr Leaper can come in if he wants to add from the noise perspective. I don't think Mr Jameson himself has raised noise as a ground of objection, but just so that he's aware that that potential issue has been properly taken into account by the acquiring authority.
That. Now, when you started that bit of your discussion, I took you to say that you were giving some examples of what you're describing as non-material objections, and you mentioned the reduction in property. Are there others you wanted to mention as well?
Just very briefly, apparently impacts throughout construction, the construction process is a non-material objection. Problems and issues with notification and engagement are classed as non-material by the planning authority regarding objections. So I just bring them to the awareness of yourself that despite having made objections on these fronts, yeah, we have talked about a couple of these things. They are deemed as non-material by the planning authority. I'd really just like to very, very briefly go back to what was just getting talked about there. I struggle a little bit with the phrase residential amenity regarding my house, my home, my castle. Residential amenity is not particularly an issue I have ever raised. Yeah, I've acknowledged here today that I have no line of sight to the substation. I have not made a complaint about noise. Yeah. However, I insist that when all these projects, including the acquiring authorities projects, are up and running and in mid-construction and fully completed, yeah, there is an extremely high risk, which I will say again, I cannot demonstrate today, that it will devalue my property. I also accept and understand that it's not the purpose of this inquiry to address that issue. Yeah. But I would like to get it on record that it is a grave concern of mine, and I'm sure other people, that further down the road, I will remain as lost as I am today, trying to navigate the processes that are laid before me in this country's legislative system. So enough said on my property
Actually,
value.
before we move on from that, at the site visit, we looked at the Branxton substation, and you made a point looking at the field to the, well, it seemed to be the back, the bit that's furthest away from the coast. The back of that, there was a field in which there was a request under this order for cable rights. You made a point on the site visit that you felt this was a kind of thin end of the wedge, that once the existing substation is combined with what's proposed here, there would, as a matter of inevitability, over time, be more and more development, and there'd end up being an increasing cumulative negative impact at that part of that area. Now, I don't know whether you were intending to develop that as a separate point, or whether this is a kind of variation of what you've been touching on now under what I've got as noted as question 5. So I don't know if you want to say something about that, whether it's the same point or whether it's a slightly different point.
Well, it's essentially the same point, but it's a point that I think I've already made. Yeah, I feel as if I've already made regarding cumulative development. I believe when you and I spoke in that field on that rainy day, that it was the thin end of the wedge, and it has proven to be so. Yeah, it is now apparently open season for anyone to come along to my neighbourhood, yeah, with their development proposals for whether it's solar farms, battery storage, what have you, yeah. And it is now just fair game for anybody to come along and connect into this yet to be approved Branxton substation. And it just is a never-ending fight for myself and my neighbours, my friends, my colleagues, yeah, who I'm not speaking on behalf of, yeah, because I'm not permitted to speak on behalf of them, yeah. But they exist, these people exist, and they are getting impacted by all this development that it's just, it's unchecked, it's uncontrolled. The controls that are in place, I think, are unsuitable. They're too fragmented, and it's just doing the people, the residents, a huge injustice, yeah. And I'll say again, there are not that many residents, yeah, but that does not make it any less important to be having proper conversations. In fact, it enables better conversations, I believe, to be taking place with the residents and the community. You're not trying to communicate with 30,000 people here. You're trying to talk to 290 people. It could be done on a face-to-face, one-to-one basis. Get us involved. Make us part of the solution. That's what should be done, I believe. Beginning to run out of steam, quite frankly, sir. It would probably help me, actually, if you don't mind. I'm getting a slightly a bit dry, and have you? Yeah. So.
Give ourselves just more than 15 minutes, but try to come back sharp at 3:30, yeah. And then we can try. at that point to get through as much as we can in the time we have.
Yeah,
It would be useful. I mean, it may or may not be possible if you're beginning. I've got some questions arising as well, but it would be useful, I think, for your own sake, to try to finish your evidence this afternoon. And I'm happy to sit a little bit beyond 4 o'clock, then maybe not much, because some people have got a long way to travel. But if that can avoid us having to sit tomorrow, then that might be some benefit for that. But if we can break till 3:30 just now, and you can gather your thoughts and speak to those who are here supporting you, and that might allow you to usefully develop your further argumentation in the kind of remaining half hour or a bit beyond that we take this afternoon. Whether there's more coffee or not, I'm not entirely sure. I can't promise that, but we'll break now till 3:30. Thank you.
Thank you.
Okay. Okay, if we could just then reconvene, and thank you for your cooperation in resuming your seats quickly. I said to Mr Jimmerson before the break I had a couple of questions, but he may have others that haven't been fuelled by chocolate cookies and coffee. He may feel he's able to carry on his list of questions, and we can take that from there. And you may want, after your questions, just to draw together some of your thoughts before we close for this afternoon. So I'll leave to you first of all, but as I said, a couple of things I was going to ask about things that you mentioned again on the site visit back in August, but over to you first.
Okay, thank you very much. I won't take much more of your time because, quite frankly, I'm nearly on my knees. Couple of things, however. Thank you for this briefing paper, a couple of pages regarding the emissions reduction target. I've read it. It's very, very interesting. I think the only thing I would like to sort of bring to the sort of reporter's note is that there is a perceived risk by me. I think there is a risk that because one deadline has been missed or one set of targets has been missed or changed, there is the retention of the 2045 net zero target. There is a risk that everything will be hurried, and therefore less diligent and well thought through as it perhaps may have been. I think that's a big risk, not just for me, but I think for the country, and I would therefore ask whatever guidance or feedback to ministers can possibly be given by the reporter, but that is a risk for others. My last sort of general point is I'd like to introduce a document which I'm sure a lot of you are familiar with. I, to be honest with you, was not familiar with it until I embarked upon this exercise, and that is the Aarhus Convention. It's worth saying that I know where Aarhus is because I've been there. My grandmother is Danish, but other than that, I don't know too much about it. However, in light of the time and my energy levels, I'm not going to wade through this ridiculously for ages and ages. But I just like to summarise my understanding of what it is. This is a well-thumbed copy. I understand that our country is a contracting party to this document, and that therefore, if my understanding is correct, and I understand that yourself is somewhat of an expert in this, that because we are a contracting party, everything that falls under that should therefore be in compliance, roughly, with this document. So similar to things that I've said previously, I am contending that there is no particular demonstrable compliance with this convention, in the processes that are in place by either Scottish Government or ministers or East Lothian Council regarding planning or the ECU, and quite frankly, public participation in decision making is just a woolly phrase that is not getting enacted. And that is genuinely my feeling and experience in regard to my own little area of the country. I don't feel listened to. I don't feel as if I've been given the opportunity to truly participate. And that's despite everything that I read says that I should be given that opportunity. And that just concerns me. But as I say, just in the based on the time constraints that we have, I've made 101 notes on this. I'm not going to bore you to death, sorry, with this, but my suggestion is that the country and those that work within the country are not really acknowledge that and deliver on their promises for what they call their just transition and the likes. Again, nobody knows what that phrase means, but I see no just transition in my area. It's just been completely foisted upon us, and we're going to have to live with stuff as and when it gets approved. And that's unfair, disappointing, and it angers me enormously. So, I've no more to say, sir. I will let you ask your questions.
Absolutely, thank you. I'll come to the Acquiring Authority just in a moment. I'll maybe, if I could just maybe refer to three things, not to let you off too quickly, since you thought you were finishing there, but there was 2 or 3 things that you mentioned at the site visit in August that had clocked in my mind, and because the site visit isn't an opportunity to lead evidence, I said that I'd like to return to these when we go into a more formal session. It's taken 9 months to get into the more formal session, but here we are. And the 3 that I've asked you about one already, about the kind of the future of the Branksome site, so I've asked you one of those questions. But there are 3 others that came to mind. One of which is, you made a call at the very beginning of the site visit. We were looking at close to the Skate Raw car park. We walked around the front along to the seafront, and you had a concern. I can't now remember whether it was a triple SI or a special area of conservation. There was a protected area there, and you were concerned. I think it's maybe only to do with kind of construction impacts on that, but you expressed a concern that there was adequate protection of the triple SI or SAC at that, and I wondered whether you wanted to say anything for the record now, because you mentioned that there, as I say, and now's the chance to put something on the record, and the Acquiring Authority may want to respond. So that's the first one. I'll let you say if there's anything further you want to say about that, then I'll go on to the other 2.
Okay. Not particularly on that issue. I mean, I think that issue has been put to bed, as far as I understand it, where the cables come on shore is immediately adjacent to a triple SI. That was a planning thing, so I wasn't about to introduce that today. At that time when we did,
that was pre-planning.
When we did
I appreciate that.
That site visit, that was pre-planning. Yeah. I certainly wasn't going to bring that up today. One would hope that the planning authority have been diligent and done their reports and things from all the other agencies. So I've got no comment on that.
Okay, the second one might be in the same vein. Again, very close to the car park, we went up a hill and you looked round and looked out onto the sea, and I think you had a concern there about the impact on the viewpoints from there as well. But again, that may be something that you think is effectively superseded by the planning process, rightly or wrongly, effectively or not effectively. But you did make a mention there that you thought there was a potential adverse impact looking out to the sea, I think, from the small hill just above the Skate Raw car park.
Yeah, I distinctly remember where it is. I distinctly remember taking that walk. At one point, I had concerns where the cables came ashore, And one of the engineers that was there today, he assured me that I think they were, I can't remember what you call them, cable pulling winch pit platform things that would be a very transient and temporary thing. So I have no issue with that. But that particular area where we were,
yes.
I think that subsequently came back into the sort of conversation.
Yes.
When myself and I think Dunlops were talking about the potential for moving the substation. So that is the sort of zonal area where that is.
Yeah.
The acquiring authority suggested that that was an unsuitable site due to previous waste, landfill stuff.
Landfills, yes.
I'm not going to go over all ground. I personally think that would be a better site for it, but way down, out of sight, out of mind, down by the industrial complex that is Torness. But we've been down that loop.
Okay.
But that's exactly where we were the other day.
And the third one, you mentioned that you felt that there needed to be a more imaginative or more holistic approach to where the underground cable should run. And I remember there's the road up from the Dunlop site that goes up to Berwick, and I think as you would go up the hill, I think the proposal from the acquiring authority is to put their cables to the field to the left of that, and you were saying there's some Scottish Power cables that are either there or proposed to the field to the right, and I think one of the questions you raised is why don't they better get together than they had done prior to that and use one set of cables and one set of undergrounding. I think holistic was approach, or imagine, I forget the exact words you used to describe it, but you'd raised a point there as to whether you thought there was some scope for some better cooperation between the various authorities in relation to that aspect of things. And I don't know whether you still have that view or want to make any sort of further points about that aspect.
I'm absolutely still of that view, but I think that is a product. The issue that I highlighted to you and you are now playing back is a product of the fragmented way that this entire geographic area has been treated. We've got large companies doing large things, and they're very focused. There is no consolidated effort to minimise disruption, upset, annoyance on the community. It's just, rather than a well-meshed, finely oiled machine or jigsaw, just a bunch of builders coming along doing their own things, which maybe is a little bit disrespectful, but efficient delivery and construction of the project, I think, is key, and that has been an ambition of lots and lots of community engagement, trying to engage with the developers, which has proved hugely difficult, because for whatever reason they're all very protective of their own wee piece of the pie, but as I say, it manifests itself as almost as ridiculous as you and I walking up that road, and here's some Scottish Power cables, and here's some SSE cables on this side of the road. Different landowners, different fields, different constructions, different this. I firmly believe to address public upset, there could be something that is, and I don't know what it is. I don't have the answer, but is mandated that there needs to be far better coordination and cooperation between these organisations.
Okay, thank you. Thank you. I'll pass over to the Acquiring Authority, and I wonder if you could draw together any responses either to those specific questions or the more general points made at the end of Mr Jimison's representations there. I'll give one more chance to Mr Jimison to have final say, and then that will allow us, I think, to close for today. So I'll pass over to the Acquiring Authority.
Well, I have 3 or 4 things that I think may require a response. Just on the last point, though, I'll come back to the issue of engagement and coordination and so on in more general terms. But on the last point, the technical issue that seems to be in the subject of discussion, I have to confess I'm not exactly clear what's being suggested, but it may be that Mr Manning is clearer and would be in a position to comment on it.
Sir, thank you for the question. In principle, the Acquiring Authority is certainly open to collaboration as referenced. However, in practical terms, there would be a requirement for both projects to have alignment in terms of programme level of design development. And as part of the engagement discussions since 2019 and earlier, there's been numerous meetings, engagements, and where opportunities arise, we'd assess them, investigate them. But in practical terms, as the need for a project such as this, as referenced earlier, could potentially be delayed by reliance on another project to execute certain works if that collaboration was to take place. So it's just the wider consideration and the certainty to deliver the project and what the implications such an arrangement may have.
And just following on from that, sir, you may have picked up in the documents lodged for the by an Inquiring Authority, in particular the project overview paper, that there's reference to the East Lammermuir's developers' principles of community engagement, which is CD 008.001.017. And there's a correction that relates to that to be made in the topic paper, sir, which we've picked up on page 22. And it's this penultimate paragraph. I think when this was drafted, it had been an expectation that Scottish Power would have signed up to that agreement, but in fact they have not. So that last sentence should be deleted, sir. But nevertheless, I think Sir Edwards would like to say a few words about how the principles of community engagement and coordination can be expected to be pursued in practice.
Yes, thank you, sir. Yes, I think just acknowledging some of the concerns that have been raised by Mr Jamieson and how we best move forward, having secured planning consent in particular, dealing with cumulative issues, and we have actively facilitated and been involved in a number of community-based meetings in Berwick with other developers and with East Lothian Council present, and also with East Lammermuir Community Council and local residents, looking at ways in which we can work with the local community around traffic management in particular, as one of the key kind of areas of concern that have been raised. And we've been working with directly with East Lammermuir Community Council and have worked with them to help develop their developer. There's an interactive map on the East Lammermuir Community Council website, which has all of the developments that are planned and proposed, and they run through pre-application, application, consented and operational developments in the East Lammermuir area, and we've been working directly with East Lammermuir Council to assist the development of that website, to make that information available to everybody in the local community by way of trying to expand our engagement and involvement of the local residents in the area.
Just worth saying, I'm grateful for those explanations of what the intentions would be. Obviously, there has been a concern expressed by Mr Jimison, and I suspect shared by those who are attending with him today. We can't change the past, but these are good positive indications as to how, at least going for the future, can be taken forward in a way that engages better and more closely with the local community. And I would urge you to make practical and real some some of those indications. Not saying you wouldn't, but it is actually, in one sense, words are cheap in circumstances like this, and planning documents are easy to reference, but nevertheless, there is nevertheless, amongst those on my right, a real sense that hasn't been as effective in the past as it might have been. As I say, the past can't be changed, but you've heard a kind of a plea for more understanding and more level of engagement, and I would just urge the acquiring authority, and it's not just you, I mean it's everybody on that side, to seek to ensure that however the project goes forward from now, or any variation of it or any different project, that it would be, I think, appreciated by those in the local community to ensure that those steps are taken in as effective a way as possibly can be in future. Thank you.
Thank you, sir. The second point that's worth coming back to is very briefly in relation to the Aarhus Convention. I don't propose really to say anything beyond what's already said on page 24 of the hearing statement, except to observe, sir, that ultimately Mr Jameson, I think, accepts he's had access to the environmental information, and he's been able to participate in both the planning application discussions before committee and, of course, throughout this process in relation to the CP order. And the third point, sir, relates to the mention that was made of Mr Bell's briefing notes. Now, although it was introduced this morning and Mr Bell made brief reference to it, just from a procedural point of view, sir, would you like Mr Bell to go into that document in a little more detail just now, or would that be best left till tomorrow morning in relation to the common topics session? I don't think Mr Carroll confirmed one way or the other whether he intended to say anything about it.
So it may well be that Mr Bell would like to say a little bit more. Conscious Mr Carroll's not here, but just before I do that, I promised Mr Jimison I'd give him last word on his session. If there is anything, he shouldn't feel the need to say anything more if he doesn't have anything more to say, but if he wants to say anything more, I did promise him last word on his session, and then we'll ask Mr Bell perhaps just to close for this afternoon with anything further about the announcement last week and the document now lodged. I see it's got a number now as well, so I'm grateful to those who've been organising that. So,
thank you. Very, very briefly, just echoing your phrase you used there, sir. You used the phrase "words are cheap." I would agree with that phrase. The words are extremely cheap. I'd also slightly take issue with the fact that you're essentially trying to claim for facilitating these subjects, these sessions. Quite frankly, developers have been dragged kicking and screaming to these sessions. They have not been organised by yourselves, the community council, some of which are sitting behind me. They've done a hell of a lot of work trying to do this. The acquiring authority hasn't facilitated very much, quite frankly. So please don't claim so. Other than that, I'm finished for the day. Thank you.
Thank you, sir. Yes, the note hopefully is helpful in just summarising the position which emerged at the end of last week, and I think most people have probably seen the newspaper headlines that came out on it, and there's been some
the BBC website today as well, I noticed, under reference to this.
Indeed, and some of the wording that's been used is targets abandoned. I think that was used today by Mr Jameson. Others have used the word scrapped and so on. It's very much an adjustment position, and I think, as Mr Jameson said earlier, that 2045 remains the target for net zero, and that's a legally binding commitment, and that has not changed. And earlier on today, I mentioned the Climate Change Committee's reports that have come out over the last few months in a staged way, mainly directed at the UK Parliament, and saying that, look, you're off track in terms of 2030, and more needs to be done. And the March 24 report that is now before the inquiry is the one that went to the Scottish Parliament, and that said effectively that the statutory 2030 goal to reduce emissions by 75% is now beyond what is credible. And the Scottish Government has responded to that in the statement from the Cabinet Secretary, and the statement terms are reiterated in the letter to the convener of the Net Zero Energy and Transport Committee of the Scottish Parliament. Because it was the Scottish Parliament that agreed the targets that I have set out in my topic paper, and there is a key table which is 2.1 on page 14 of the topic paper that sets out the annual targets running up to 2045, and it includes the in 2030. Now in delivering. Also on page 11, it states that there has been better progress in renewable energy generation with a ramp up in offshore wind capacity in 2022. And it goes on at page 18 to say it is identified that there has been some progress in offshore wind capacity, but that growth in onshore wind capacity has slowed. And then it goes on to say on page 66, it is observed that NPF4 is a key lever for considering major infrastructure and aims to encourage, promote and facilitate all forms of renewable energy development. And clearly the development that's the subject of the order is a national development in NPF4, namely National Development 3. So in light of these points that are within the CCC report, there are 3 points arising. One is the ongoing policy support for offshore wind generation. That is commended by the Committee on Climate Change. And secondly, the committee is anxious to ensure that momentum continues, particularly in light of poor progress of other sectors that are explored in the CCC report. And the third point is that these findings ought to have considerable influence over ongoing Scottish Government policy. And in the statement of the Cabinet Secretary, she does say that the CCC is a key partner in the net zero journey. So I think there's an expectation that the CCC's position will be taken on board, not only in terms of the legislative change that's still to come, but also in terms of delivering now And I think the key message is, because 2030 75% reduction will be missed, it's not credible, that doesn't dilute the need to continue to deliver more capacity, and that's what this project will do. And I think it's the scale of this project that is probably exceptional in terms of all the other offshore wind projects in Scotland, and therefore the benefits that it can deliver. So lastly, I would say, although the target will be changing, it's simply a change in the trajectory to get to net zero, but that overall goal is maintained. And hopefully that has been a helpful explanation in the paper about what these headlines have meant over the last few days. Thank you.
Sir, just an observation. Mr. Bell referred to page 66 in the context of electricity supply, and I think you read from the second bullet point on that page. Is that right, David? Can you get David a copy? It's the bullet point there is in a wider discussion about the electricity supply and the fact that the Scottish Government has consulted on its draft energy strategy and just transition plan. And I just noticed that towards the bottom of the page, where it says to be addressed, that the final plan is due in the summer of this year, and it would include a delivery plan on how Scotland will achieve the vision for the energy system set out in the draft. And in the next bullet point, the Scottish Government should work with the UK Government to ensure that targets for Scotland set out in the ESGTP are met, and that the UK-wide objective of a decarbonised electricity supply by 2035 is achieved, subject to ensuring security of supply, and so on. I just wonder whether any observations to be made in relation to that also.
Yes, I have referred to the draft energy strategy and just transition plan in my topic paper, which is CD 006.005. And we're clearly waiting on the final version, which is the reference that Mr. Mackay has taken us to in this CCC report, the latest one.
So just looking to the top bullet point, although the 2030 net zero target is likely to be amended, the draft makes reference to an ambition to deliver more than 20 gigawatts of additional renewable generation capacity by 2030, including 12 gigawatt onshore wind. What expectations do you have in relation to make up the shortfall by offshore wind?
I think what the CCC report is saying is that onshore wind is slowing down, and if you look at the consenting rate that's required of 1.4 gigawatts a year for onshore wind, it's probably unrealistic. So if you've got a project here that can deliver 4 gigawatts with one consent, that is a major contribution to that shortfall. It could be. Yeah, yeah.
Okay, well, unless there's anything else, Mr. Mackay, I think that probably will just about manage to meet a 4 o'clock deadline for closing today. We've gone a few minutes over. I think we probably are okay now to reconvene on Wednesday morning with the inquiry session into relation to the objections by the LOPs. And then we can, depending, I think we're 2.5 days set for that, and we'll see how that develops, and then we can take a check as to where we are for remaining objections that require to be dealt with by oral procedure, which is back to hearing procedure. But unless anybody else has any other points, I'll thank you for your cooperation and evidence and support getting through a good bit of progress today. I was hopeful that the common issues sessions, which at one point were looking like a fairly major part of the examination, are largely, in fact, covered in writing, so we've been able to cut through an awful lot of those today, and I'm grateful to parties for that ability to do so, even if it's given me an awful lot of reading to do, but that can't be helped. So thank you again, and don't forget any and all of your valuables. As I say, we can't leave anything here tonight, and we'll reconvene at 10 a.m. on Wednesday morning. Thank you.